can go like this to you or something.
Recording in progress.
Your Honor, calling People versus Ethan Crumbley, case number 279506 FC.
Thank you and good morning. Council appearances for the record.
Good morning, Your Honor. Karen McDonald on behalf of the people of the state of Michigan.
Thank you, Mark Peace, on behalf of people.
Good morning, Your Honor. David Williams on behalf of people.
Call up Michelle Lofton on behalf of Ethan Crumbley.
Amy Hopp on behalf of Ethan Crumbley. Good morning, Your Honor. Deborah H. McKelvey on behalf of Ethan Crumbley.
Thank you and good morning to all council. You may all be seated. Defense ready to proceed with your next witness?
Yes, I could just have a moment to connect the PowerPoint, please.
Absolutely.
Defense will call Dr. Colin King to the stand.
Thank you. Doctor, you're going to approach the witness stand. You're going to stand in the witness box, face my clerk to be sworn, please.
Please raise your hand. Under penalty of perjury, you swear or affirm the statements you're about to make to the court will be the whole truth.
Thank you. Good morning, sir. If you could please state your full name for the record and spell your last name.
Sure. My name is Colin King. C is in Charlie, O-L-I-N, last name King, K-I-N-G.
Thank you. Defense your witness.
Thank you. Dr. King, I'll let you get situated. Let me know when you're ready.
Thank you.
I am ready.
Okay. Doctor, what is your highest qualification for education?
I have a PhD in counseling psychology
And where did you obtain your degree?
from Wayne State University in Detroit, Michigan.
What licenses do you hold?
I am a fully licensed psychologist, and I'm also licensed as a professional counselor, so I'm dually licensed.
What certifications do you have?
So I'm certified as a board forensic counselor, a board certified sentence mitigation specialist, a certified advanced addiction specialist.
Have you ever had your license revoked or suspended?
No, ma'am.
Where did you do your internship?
So I did an internship in Michigan City, Indiana. And that's at a psychiatric hospital that treats children, adolescents, and adults. And then I did a second internship at Southwest Detroit Community Mental Health, working with patients with chronic mental health issues and poly substance abuse.
Your Honor, just for the record, it appears the witness is consulting some documents. Can we just identify what those are?
Thank you, sir. What do you have that's currently with you on the witness stand?
Sure, I submitted a copy of my CV.
Thank you. And is that what you're referring to?
Yes.
People, do you have a copy of the CV?
Yes, Your Honor. He's got a whole binder. I just want to make sure I understand what he's consulting.
Yeah, I can absolutely tell you what is in my binder, sir.
Sure, there's no need, sir. If you could please set the binder aside and let's specifically ask to refer to it.
Okay.
Thank you. You may proceed.
Absolutely. Your resume indicates that you also lectured at a number of universities. Can you describe that?
Yes, so as an adjunct professor, I've lectured at Wayne State, Eastern Michigan University, Ashland University, and University of.
And what courses did you teach there?
I taught classes in multicultural issues and psychological testing.
You also worked as a special education consultant, is that correct?
That is correct.
And what did you do there?
I consult with one of the charter schools in Michigan, doing IEPs and psychological testing.
You also have listed that you are a brain injury expert. Can you tell me about your experience treating brain injury and or mental illness?
Absolutely. So I've worked with a large Midwestern brain injury facility, actually one of the largest in Michigan. And over the last maybe 23 years or so, I have treated various forms of brain injuries, mental illness, and patients with poly substance abuse. In fact, I was tasked as a part of my assignments, tasked with supervising teams of occupational therapists, physical therapists, nurses, and psychologists. I've traveled to different states and met with neurologists and assessed patients who were injured due to maybe auto accident or spinal cord injury or stroke. Had an opportunity to look at their medical records and review their records with physicians, and then return back to Michigan and set up treatment programs for.
I understand what he's consulting.
Traveled to Loma Linda University, which is one of the largest, which has one of the largest cadaver labs in the nation, and had opportunity to meet with a neuropathologist and got a chance to look at various models of the brain, to handle the brain and to see how it works. I've also attended various lectures at the Amen clinics, and you may know he's the award winner on Change Your Brain, Change Your Life. I actually had my own brain scanned, and so that gives me my experience in brain injury.
Have you ever testified at any juvenile life cases before?
I have.
In what counties?
Wayne, Macomb, Genesee, and I think Jackson.
In the last 3 years, approximately how many juvenile lifers, homicide, or competency cases have you testified in?
Probably about 24, 25.
Have you been previously qualified as an expert?
Yes, ma'am.
At this time, I move to have Dr. Colin King as an expert in mental health, forensic psychology, and brain injury.
Judge, I understand he's interviewed. I'm sorry, may I, Judge?
Yes.
I understand that he's interviewed the defendant and he's here as a mitigation specialist, and I don't have any issue with that. There's nothing in his report or in the record to indicate that this defendant had any kind of brain injury. So I would object to his qualification on that simply because it's not relevant to this proceeding.
Thank you. As it relates to any brain injury, unless there's going to be foundation laid that this defendant has a brain injury, then that's not appropriate. However, I will qualify this witness as an expert in mental health and forensic psychology. Is that correct?
That is correct.
He is so qualified.
Thank you.
Thank you.
Your Honor, we do have a demonstrative PowerPoint to explain his report. All right, so I want to go over the process that was taken. Is it working? Yeah. Just go to the next one. So let's start with the process. It is my understanding that you became involved in this case in December of 2022. Is that correct?
Yes, ma'am, that is correct.
All right. And can you tell me what you did first?
So I spent approximately 23 to 24 hours testing Ethan Crumbley over about 6 sessions. And I used about 15 different assessments, and I've turned in my report, which is about a 6 to 9 to 70 page report.
Some of the testing, was it done in person?
Yes, yes, ma'am.
And then some of the testing, was it done on computer or by Zoom?
It was done virtually. Yes, ma'am.
So you interviewed him multiple times, approximately 1 year after the incident, a little bit longer than 1 year, is that correct?
That is correct.
Were you also given a litany of records, videos, text messages, and reports to review?
Yes, ma'am.
Did you then do research to gather data and establish the standards that are required?
I did.
Here we also have that you consulted with a Dr. Malcolm Court, that is a sociologist. Why is it important to peer review?
Well, because I wanted a different discipline to look at my work and to provide me feedback on my work. I wanted to make sure that it was not just my personal opinion, but that my work was based on testing and solid scientific evidence.
And Your Honor, I'll draw your attention to Exhibit O, the CV of Dr. Malcolm Court, and Exhibit P, the report of Dr. Malcolm Court, which reviews Dr. King's findings.
Thank you.
You want to move to the next one?
Judge, if I may, I believe we stipulated the admission of exhibits with the understanding Dr. Court was a witness. And so I had some questions for Dr. Court, and now what it sounds like is he's not going to testify. So I have an issue with the court using his report as a basis, as evidence in this case, without the chance to cross-examine.
So Dr. Court was not listed on my witness list. I did have conversations with Mr. Keys, the fact that Mr. Court would not be called. This should not be a surprise at all. And they did not object to my exhibits.
Judge, I'll do with this to weight of the evidence the court should consider. Thank you.
Thank you. The court will apply the appropriate weight, noting that the doctor will not be testified. You may
Thank you.
proceed.
So as a brief overview, what is it that you looked at in regards to this case to form an opinion?
Sure. So I looked at Ethan's early life. I looked at the parental influences and activities. I looked at the Oxford school system, testing results, events leading up to the shooting, the day of shooting, and a review of mental illness.
I'll move to the next one. All right, so let's talk about early childhood experiences. Can you discuss that?
Absolutely.
Again, Bernie, he's consulting.
He has the
something.
PowerPoint.
Okay, it's simply the PowerPoint.
Yeah, this is this is an exact copy.
Let me step in. Anytime you're referring to something on the witness stand, the parties need to be aware of what you're looking at. And so you just can't just pick something up and start reviewing it. First, the defense attorney or the prosecutor has to prompt you to look at something. So what are you currently looking at, sir?
I have an exact copy of the PowerPoint that is on the screen, sir.
Thank you. And that's the only thing that you're looking at right now?
Yes, sir.
Thank you.
Thank you, Your Honor.
Thank you. You may continue.
Thank you. All right, so let's start again. Early childhood experiences. What did you come across when examining all of the evidence and discussing the matter with Mr. Crumbley?
Certainly, in my review of the records, I saw that as early as age 10, matter of fact, even going back to age 6, there were some issues. Early as age 6, you'll go across to the neighbor's house, especially when there was like a thunder shower, and reported that he was afraid and would ask for help. And they would ask him where were his parents, and his response was, "I don't know." In the records, at age 10, there's text messages between Ethan and his mom saying to her, "When are you going to come home?" And there were no responses. In my interview with Ethan, he explained that he spent countless hours watching various adult games. Some of them are in my report, and Assassin's Creed, Grand Theft Auto, and he also spent an inordinate amount of time going to different websites and indulging in various graphic scenes, and indicated after a while he began to fantasize about being part of those scenes. So he sort of lost track of reality.
You also have listed trauma. What is trauma?
Trauma is sort of an parental discord. It could be as a result of high levels of anxiety or high levels of depression. Anything that insults the person's brain can be classified as trauma.
What about constant stress from parents fighting?
Yes, parental dysfunction, constant and intense dysfunction can induce trauma. In my interview with Ethan and in a review of the records also, there's frequent references to either parent threatening to commit suicide. And on some occasions, Ethan has had to be the one intervening at such a young age.
What about the loss of a grandparent or the loss of an animal, especially in a violent death?
Absolutely. Ethan disclosed that one of his sort of soulmate was a large dog that he had cherished, and it died at home, and he was the one tasked with having to remove it and take it back to the shed and figure out how to dispose of it.
And you saw the Google searches where he actually is looking how to dispose of a dog that has passed away. Is that correct?
Yes, ma'am, that is correct. This could be a pretty traumatic experience, as in the case of Ethan, and as seen in the record, he spent hours and hours communicating with his best friend and pouring out his heart and disclosing what was happening to him.
Were you also told what his mother told him when that friend went away to a rehab?
Yes, ma'am.
And what was that?
She told him that he would probably never see his friend again.
Let's move on. Dr. Keating, when he testified last week, touched on ACEs. Can you explain what that is to the court?
Yes, so I think in 1995 and 97, my year could be off. The CDC and Kaiser commissioned a study where they looked at 17,000 people. And they have established what is called ACEs, or adverse childhood experiences. And what the researchers saw was discovered is that 6 or more and I have no recollection of that event. And in another text message on your screen, he said to his friend, I am hallucinating. And he said, I hear like people talking to me. These were actual text messages back and forth between himself and his friend.
I want to move next to part 3, which is the Oxford school system. Were you able to take a look at the counseling that was available to Ethan at the school, as well as the reports surrounding the school's interaction with Ethan the day prior and the day of the incident?
Can you repeat that question?
Sure. Were you able to look at Oxford school system and their counseling program, as well as the interaction that the school system had with him the day before, as well as the day of the incident?
Yes, I did.
Okay. And can you explain what you found?
So what I found was that in terms of the resources for intervention, it did not appear to be from my review of the information that he was afforded any type of mental health assistance.
You also mentioned in your report implicit bias. What is that?
So implicit bias it's sort of like the unconscious forces. You know, I can use an analogy of a peanut butter jar, which is actually on one of their slides. And so a child learns how to use peanut butter from a jar because the child is taught by the parent how to do that. They learn how to unscrew and cork and unscrew the peanut butter jar to get peanut from the peanut butter. So after a while, they learn it so well that they're able to do it unconsciously. The grooves on that bottle represent the grooves that society grooves us with, so that we have certain perception of things and people. Well, that's how implicit bias works. Let me give you another quick example. I was in court in Detroit and about to step into the elevator, and there was an attorney and other people. I was dressed in suit and tie, and the attorney turned to me and said, "Counsel, come on in." I'm not an attorney, but he made the assumption based on how I was dressed and how I comported myself that I was an attorney. Well, that's how implicit bias works. So it's not necessarily a bad thing nor a good thing. It's a thing, but it can have deadly consequences if it's not used appropriately.
Now, you also stated that you had a chance to look at the resources that were available to any high school student at Oxford High School. Is that correct?
That is correct.
Okay. And is there a rubric or is there a standard that is required for a school to have counselors, to have support staff, or to be able to help the students when they have issues?
Certainly. So the American School Counseling Association, known as ASCA, this is sort of like the monitoring body that makes recommendation in terms of social worker to student ratio. So the recommendation is that there be minimum one social worker to about 250 students. And what that body says is that if you have a ratio of one social worker to 1,000 students, you are not even getting into the classroom.
Were you able to find the data, and I know that it's contained in your report, regarding Oxford in the year prior and the year of the incident?
Certainly.
Okay. And Your Honor, just because they're numbers, I ask if it's okay that he refer to his notes just to get the numbers correct.
Thank you. Any objection?
No, Your Honor.
Thank you. You may, sir.
So in the 2019-2020 school year, what was the social worker to student ratio in Oxford?
So it was approximately one social worker to about 1,000 students.
What about 2020 to 2021?
It was one social worker to about 900 students.
And then what about 2021 to 2022?
It was about 1 to about 900 students.
So you went even a step further to look at your findings.
So in my research on the Oxford school system, just in terms of raw data, I saw that whites comprised about 80% of the school district's enrollment. And blacks comprise, I think, about just under 5%, and Hispanics about 12%, which is reflective, I believe, of the society. So there was nothing revealing about that. However, when you begin now to disaggregate the data, because data tells you something, so that when you begin to disaggregate it, you see a pattern, which is visible on your screen. So whites, 80% enrollment. And in terms of suspensions, 68% of the students suspended were whites. Blacks enrollment, 5%. So 12%. Let's look at expulsions. Again, whites, 80% of the population, expulsions, 44%. So about half. Blacks, 5% of the population, expulsions, 22%. Hispanics, I think about 12% of the population, expulsions, 22%. What this data is telling you is very significant, is that all the students are suspended or expelled at a disproportionate rate when considered to the majority population. And then when you dig a little deeper, you have to ask yourself, what are we missing? And as it pertains to Ethan, as you will see, is that the students are not subject to the same degree of rigor, which is why implicit bias is so important.
Okay. And can you explain, just so it's clear, how implicit bias ties into these findings?
Absolutely, because if you believe that a student is not a problem, you are less likely to pay attention to that student. Even if you are shown overwhelming evidence about problems. Implicit bias says, you give this person a pass because that's how you've been groomed. You make certain assumptions. So you give certain people a pass based on your assumptions. However, if you give a person a pass who is a problem, it creates a bigger issue.
So I want to go into a little bit of what you call a pass. You were shown a number of assignments that were found in Ethan's backpack, correct?
Yes, ma'am.
And you would agree with me that, in your honor, these exhibits can be found in Exhibit C.
Thank you.
There is a number of pieces of paper with bullets. I know the prosecutor made mention that we aren't 100% certain that these were seen by teachers, but they were in his backpack, school assistants, correct?
Yes.
Were you also able to look at emails between the teachers the day before this incident as well as the day of the incident, discussing the things that had come to light from the teachers, trying to give warning to the people in the office?
Yes, ma'am.
And Your Honor, that's also found in Exhibit C.
Thank you.
And what did those emails show to you, or how do they tie into implicit bias?
So just looking at the emails, I was, just red flags went up. It's one teacher who said, it's on their screen as an exhibit. And this is from Miss Krapinski. She said, I know Jackie emailed you guys yesterday with some concerns about Ethan Crumbley in our first hour class. Today, he's watching videos on his phone and a guy gunning down people. It looks like it's a movie scene and not security footage, a real event, but definitely still concerning when taking into account some of his behaviors. I continue, and this is from Ms. Kubini. I had a student doing first hour. Who was our day. Didn't get a chance to investigate it a bit further since it was at the end of the hour. Now that he's on my radar, I'm also noticing that some of his previous work that he completed from early in the year lean a bit toward the violent side. Doing my fifth.
And we can tell the time on that email is 9:33 a.m., correct?
Yes, ma'am.
Okay. The assignment that Ms. Kubina is talking about, you had a chance to look at, and it's contained as well in my exhibit. It's a note card where a gun was erased, correct?
That is correct.
Okay. And there is also a drawing of a person with an arm outstretched with the gun, correct?
That is correct.
So I want to get into the brain and mental illness. You can go to the next one. What is mental illness?
So it's a substantial disorder of thought or mood that significantly impairs judgment, behavior, and the capacity to recognize reality. Mental illness is actually a symptom of a deeper problem. So, for example, if someone has a chest pain is a symptom of a deeper problem. It could be a pulled muscle, or it could be because of a heart attack. So mental illness is a sign of brain dis-ease.
So there are multiple ways to study the brain, is that correct?
Yes, ma'am.
Can you briefly discuss those different ways?
Certainly. So one way is to look at the brain directly. So cardiologists look at the heart, dentists look at the teeth, and mental health people should look directly at the brain through various brain imaging techniques which are available. So that's one way. A second way is you want to test the brain directly through psychological instruments. Then a third way is what is utilized by psychiatrists and psychologists, and that is they use symptom clusters. So for example, if someone comes to me and they say, for the last month or so, I've not been sleeping well, I've not been eating well, I've been skipping out on work, I've been crying, I've been sad and blue. Then I go to the Diagnostic and Statistical Manual, the DSM, and I look at symptoms. And if the person has, for example, 5 of these 8 symptoms, then I can diagnose that person like with major depressive disorder. So that's the third way of looking at the brain. And then the last one really is not appropriate, and that is that you guess. So what you do, you say, well, because I see you acting in this way, and because you can plan, and because you can execute, and because you can do these things, I know that you're not ill or don't have a brain dysfunction. That is guessing.
So were you able to actually look at the brain directly through imaging?
I was not able to.
Okay. So did you then decide to test the brain using assessment tools and perform a number of testing?
Yes, that is correct.
We'll go to the next one. The brain and exactly how easy it is for the brain to be damaged in a variety of ways.
Absolutely. So
Judge, I'd just like some foundation. No, I'm sorry, Judge, I'd like some foundation for this area. There's just no evidence in the record that this defendant suffered any brain damage.
Thank you. Please lay more foundation.
Absolutely. Were you able to view a video taken at the 5-1 diner?
yes, I did.
Okay. And in that video, actually, we'll go ahead and play it now since it's
But I would like to
Sure.
emphasize.
1 second. She has to ask a question. Can't interrupt.
sure. So were you able to, in your discussions with Ethan and the evidence that you were presented, were you able to, or did you have some concern that an injury to the brain could have occurred based on what he reported as a child and what you saw in this video?
Yes.
Okay, let's go ahead and play the video. This is my exhibit R. There is no sound in this video. So this is from 2020. What did you observe in this video?
So I observed Ethan walking in the diner, and for some inexplicable reason, his head takes a direct hit to the floor, and observed him trying to get up on his own volition, but he was not able to. And the brain is very soft. It has the consistency of soft butter or raw egg, and it's housed in this very hard box called the skull that has very sharp ridges. The brain is very susceptible to injury, and I would love to do a demonstration, with your permission.
Sure, Your Honor, he has a demonstration to show with an egg as he described how exactly, how soft the brain is and how little it takes to injure the brain. Would the court allow? Hold on.
Second. I'm sorry, someone was just approaching without asking permissions. I'm sorry, what exactly are you trying to do?
Yes, Your Honor, my witness would like to demonstrate to the court how easy it is, as he described, the brain is like a raw egg inside of the skull. He would like to demonstrate to the court how easy it is, even fall like this, damage the inside of the brain.
Thank you. People, any objection?
But I guess I just wonder what the basis of that testimony is. It sounds like it's just Dr. King telling us. And the idea that it's the consistency of an egg without citing anything. So like some foundation that this is not just Dr. King's theory.
Thank you. Respectfully, your argument goes to the weight of this demonstrative evidence, and so the court will apply the appropriate weight. You may approach the witness.
And can you demonstrate, since obviously this is a video courtroom and we're recording, can you demonstrate or discuss what you're going to demonstrate?
Absolutely. So as I previously mentioned,
Sir, you can be seated because I can't see what you're doing.
my apologies, Your Honor.
Thank you.
So, as I mentioned, 100 billion neurons and 1 trillion connections in the brain. And this is scientific evidence. This is not my opinion. This is how the human brain is engineered. And it has the consistency of soft butter or raw egg. I've had the opportunity to visit the lab in Loma Linda. I've handled the human brain, and I've seen how the human brain works and how it looks like. This has the consistency of an egg. Ethan is about 6 feet 2 inches tall. And this is not 6 feet 2 inches. This probably is about, I don't know, 2 feet.
Before you move on, sir, please do not, are you going to drop this egg in the courtroom? Thank you. I can't see.
I'm
over-
sorry, Your Honor.
Thank you. Thank you. You may-
Now, it makes it difficult if I don't.
So I can see what's below your chest area. So you may stand so that way I can. Sir.
So Ethan is 62, and this is less than 2 feet. That's the human brain. The reason why our brains don't collapse when we have injury is because the brain is this part.
The incident that we saw at the 5-1 diner, did he also make you aware of other circumstances where he hit his head or even blacked out?
Yes.
Can you describe that?
Yeah, Ethan disclosed that he was out with his parents. I think they were picking strawberries or doing something like that. And he fell. And all he remembered was coming to, was regaining consciousness. And he asked his parents what happened. And they said that he had taken a blow to the head. And there is no indication that he was taken to the emergency room or received medical assistance.
In regards to the 5-1 diner video, you were shown a report where the owner was interviewed. And in fact, his parents told the owner to not call 911 after that fall. Is that your understanding?
Yes, that is correct.
And in your interview with Ethan, did he ever tell you that at some point following that, he was taken to the hospital or taken to the doctor to see, 1, why he fell, or 2, what happened from the fall?
I saw no evidence of that.
Let's go to part 4. So keep flipping. We're going to move along to part 4, which is Ethan's testing. Can you explain to the court the tests that you performed with Ethan?
Certainly. So I performed 15 different types of tests. And I wanted to, because there was no opportunity to image his brain. So I wanted to test his brain to see what his brain was like. And so there are a list of 15 tests on the screen and in my report.
Okay, let's go through them. The evaluation of competency to stand trial. Why was this important?
It was important. Feign or they fake. They try to pretend that something is going on when that is not the case. So when I administered this test, anything below 60 is normal, indicating that Ethan approached this test in an honest and open manner. In other words, he was not feigning. He didn't know the questions that pertain to feigning.
And what were the results?
He does have the ability to consult with his attorney. He does understand the charges against him. And he does have a factual understanding of the charges.
Okay, let's move on to the next test, the mini mental status examination. What is that?
It's a test. that the person's orientation. My reason for asking is again, use the internet that if someone wants to feign or fake, they can easily do that. For example, some of the questions are, what is the date? What is the date? Where are you? And Ethan answered all of those questions, indicating on that day that he was oriented times 3.
Let's move to the next one. You did a survey of stress symptoms. Is that correct?
That is correct.
Can you explain your findings?
So on this instrument, on the survey of stress symptoms, Ethan scored 39, indicating high levels of stress. And it was very clear to me that he was approaching it in a very honest, test-taking manner.
And can you just describe some of the symptoms that this test addresses?
Certainly. Anxiety, depression, feeling overwhelmed, loneliness, intrusive thoughts, fatigue. All of those are elements that are present in this test that he endorsed.
Let's move to the next one, post-traumatic stress checklist for DSM-5. Can you explain what that is?
Sure, it's an instrument that is based on the DSM-5, which is.
Symptoms, is that correct?
That is correct.
Can you explain your findings?
And so on this instrument, on the survey of stress symptoms, Ethan scored 39, indicating high levels of stress. To 9, which is on that higher. Indicating very high levels of depression.
And again, you're performing these testings at least a year after he has become incarcerated, correct?
That is correct.
Let's look at the next one. It's the Burns Anxiety Inventory. Can you explain to the court what that is?
So that is a measure of one's anxiety, how anxious you are as a person, and
Fit into all of the other evidence you were looking at, the journal, the text messaging between his friend, and what he self-reported to you?
that's correct.
Let's now look at the brief psychiatric rating scale. Can you explain what that is to the court and what your findings were?
Yeah, so this instrument looks at psychosis. And what is psychosis? Psychosis is a break from reality, as evidenced by auditory hallucinations and visual delusions. And he endorsed several of those items indicating the presence of psychosis.
Let's now look at the Kaufman Brief Intelligent Test. Can you explain what that is and what your findings were?
Yes, the Kaufman Brief Intelligence Test is administered to test someone's level of intellectual functioning. The reason why I administered this instrument is I wanted to find out why was he failing. In school, average intelligence.
Let's move on to the Weschler Individual Achievement Test. Can you explain what that is and what your findings?
The next. In Ethan's case, someone who scores highly on this measure, what it tells me that this person does not have the ability to shut off those thoughts. It's like being stuck on. So you're with these thoughts every single day, every single night. And we see that with people who have OCD. You also have high levels of anxiety, and those two tend to hang together. And as you notice in this journal, you notice that repetition, that the voices don't stop. My brain is on fire. Well, when I tested his brain, is very consistent with what he was writing.
Okay. Does the obsessive compulsive disorder explain the constant searches on internet to look at violent things or to research things or any type of preparation and planning?
Yes, ma'am.
So let's move to the summary of the testing results that you performed. Do you believe that Ethan is a highly intelligent person?
I do.
Do you believe that he suffers from debilitating anxiety?
I do.
Do you believe that he is and was severely depressed?
I do.
Do you believe that he has features of obsessive compulsive disorder?
I do.
Were you able to determine that he was failing at school when, as you stated, he shouldn't have been?
I did.
And what exactly is your diagnosis for Ethan Crumbley?
So major depressive disorder, in addition to psychosis, as evidenced by his verbalizing of hearing voices and seeing things. And by the way, about 12.5% of people with major depression experience major depression with psychosis.
You have now had an opportunity after turning in your report to review the records from Dr. Kadir. She is the physician from the Easter Seals. Is that correct?
That is correct.
Would you agree with me that you have similar findings, but not exactly the same?
That is correct.
Do you have an explanation for that?
Yeah, that is not unusual. Diagnosing mental illness is not an exact science, so you go based on symptoms. So Dr. Kadir, based on my review of her notation, diagnosed him with, I think, major depressive disorder and I think an adjustment disorder. I'm going off
With
memory.
anxiety.
With anxiety, which is not unusual. But I believe as she continues, if she continues to treat him, once he has the depression and anxiety under control, if he's still verbalizing, hearing voices and seeing things, then she may add that diagnosis. So it's not inconsistent.
Add the diagnosis of psychosis or something else?
Correct.
Okay. So you have told us from your results that Ethan is of average, if not above average intelligence, correct?
Yes, ma'am.
So shouldn't he have known better? Shouldn't he have not done this because he's a smart kid?
So unfortunately, intelligence, and this is critical, intelligence does not protect someone from mental illness. So being very intelligent doesn't mean that you cannot be mentally ill.
Do you have any real world examples?
I do. Robin Williams, very intelligent Hollywood actor, but he was mentally ill. How do I know that? Well, he killed himself. He committed suicide, which we've seen that publicly. A very talented man on Ellen DeGeneres' show, extremely talented. I actually watched a video of him the day before he killed himself. He was dancing with his wife and daughter, and then the next day he drove to a hotel and killed himself. Mental illness is real.
Were you able to watch any videos that were provided to you from body cam footage of Ethan at the jail?
I did.
Your Honor, I'm going to play what is in my exhibits as S body cam jail footage. There are a few videos, but we have shortened them. This is sound, so I don't know if we can have your staff just make sure the sound is perfect. Move to the next one.
We can stop it. Why did you stop it? Why did you stop it? Why did you stop it? I know she's stop it. Please stop it. Stop it. Please stop it. Please stop it. Please stop it. Why did you stop it, God? Why did you stop it? Why did you stop it, God? Why did you stop it? Why did you stop it? You let it happen. Why? I'm sorry, please, God. I'm sorry. Please, God, God. I'm sorry, God. I'm sorry. I'm sorry, God. Oh. When you didn't stop it, and now it's always. Stop it. Guys, stop it, please. Stop it, guys. Stop, stop, God, God, stop, please, God. Oh, yeah. Stop it. Stop, stop. Stop it, please. Stop it. Yes, you did it. Stop it. Stop it. Yeah, stop it. Yeah, stop it. Stop it. Stop it. Can you hear this? Stop it. Stop it. Stop it. Way back, way back. It's all God, please stop it. You didn't 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 stop it. You said it. You didn't stop it. Oh, God, it's, you know, stop it. Stop it. That's all. That's that. Oh, God, you didn't stop it. Tell me. Oh, I didn't stop it. I didn't stop it. I didn't stop it. I didn't stop it. Yeah. It's a. All right. Yeah. Thank you. I can't figure it out. 1, 2, 3. You don't stop it. Why did you stop it? Why did you stop it? Fine. Why did you stop it? Why don't you stop it? Please stop it. Stop it. Please stop it. Please stop it. Please stop it. Please stop it. Why did you stop it? God, what's me? Why did you stop it? Why did you stop it? God. Why did you stop it? Why did you stop it? You let it out.
All right. Doctor, what did we just witness?
So we witness a child in the throes of psychosis. Or we just witness someone who's saying, God, why didn't you stop it? And that's exactly how psychosis works. You engage in an action and somehow you don't understand the outcome of the consequences. He's having a panic attack and a break with reality.
We also hear him saying you could have saved her.
That is correct.
In any part of that video, do you see Ethan being violent?
No, ma'am.
Are mental health issues perfect? I mean, he's obviously been on medication now for a period of time, and things like this obviously can still happen. What is your explanation to that?
So medications are not an exact science. There's different levels of titration. There are times when some medications work, and there are times when they don't always work, just like in the physical realm.
I want to move on to part 5. So you were able to look at the events leading up to the shooting, correct?
That is correct.
All right. Did Ethan disclose to you a situation where he actually brought casings to school and displayed them on his desk?
He did.
Can you explain that?
Certainly, he indicated to me that he brought one live round. And actually, in my review of the records and with the detectives that interviewed some of the students, one of the students did confirm that Ethan showed him a live round and shell casing. So I have no reasons to doubt what he said, that he placed some shell casings on the desk in his class. And the teacher walked by, didn't name the teacher. And I said to him multiple times, "Are you sure?" And he said, "Yes."
You were made aware and you were able to see some interviews about the events of November 30th in the counseling office, correct?
That is correct.
Okay. And it was your understanding that he was caught looking at websites dealing with ammunition?
That is correct.
Okay. Were you able to look at the actual school assignment that was the cause of him being taken to the office that morning, where he wrote certain things and drew certain things?
That is correct.
Were you also able to discuss with Ethan the video that the court has been shown that was filmed the night before?
Yes, ma'am.
And you've had an opportunity to review that video?
I have.
Can you explain that video or give it some context?
So this was a night before the shooting when Ethan recorded himself, appeared to have been using a cell phone in terms of what he was planning to do the following day. And doing certain parts of the video, he made references to demons. And then in the video, he said, "I am the demon." It just indicates the fragmentation in his head in terms of what was happening.
And what was your understanding about why he was outside at that point in time? What did he tell you had gone on in the home leading up to him being outside?
I think his parents had locked him out of the house, and they had taken some money from him.
Okay. And was that in relation to grades?
Yes, because he was failing some of his classes.
And how did he feel about that?
Terrible, in terms of how they were treating him.
The video that the court has viewed, and I know you have viewed, it seems just like a rambling of thoughts.
That is correct.
Okay.
Just sort of scrambled thoughts.
And do you believe that that is part of what mental illness can do to you?
Yes, ma'am.
Let's talk about the actual day of the shooting. Did Ethan ever tell you if he had been asked if he had a gun by any school professionals or the parents that day at school?
No.
And is it your understanding from speaking to Ethan that he was allowed to stay in school that day?
Yes, he was allowed to stay in school.
And can you explain the situation involving his backpack or how he explained it to you?
So this is how he explained it to me after he was called down to the office. He left his backpack in the classroom. And then he indicated that, I think it was Ejak. I could be butchering his name. I do apologize for that. Went to retrieve his backpack. And Ethan said, for the first time in his life, he felt relieved He said he just knew that the sheriffs were going to burst into the office and arrest him because there was no way, after all that they saw, that they were not going to search that backpack. In fact, this is a comment he made that has stuck with me. He said one of the Hispanic students was suspected of using drugs. And he remembered them searching that kid's locker. And he felt fairly sure that they were going to search his backpack. When EJAC brought the backpack into the office, he made a comment. He said, "This is heavy. What do you have in here? Bricks?" And then Ethan said, all he had to do was just unzip that backpack. But he didn't.
So the best of your knowledge, after speaking with Ethan and reviewing all of the records, the backpack was not searched, correct?
It was not searched.
So obviously at that point, Ethan had the opportunity to volunteer the information that he had a weapon in his bag. Would you agree with me?
That is correct.
Can you explain why you believe that did not happen?
He was in a state of ambivalence. Do I tell? Do I not tell? Do I do this? Do I not do this? What is going to happen if I tell? So that is the state of flux that he was in.
So I want to kind of put it all together for the court. So you've told us about a complex childhood full of trauma, correct?
That is correct.
Violence in the home,
That is correct.
mental illness,
That is correct.
a lack of resources. No one's getting him the counseling that he needs,
That is correct.
neglect,
That is correct.
access to weapons
That is correct.
in a school system with not enough counselors.
That
And
is
where did
correct.
that lead us?
Tragedy.
I want to move on to part 6. I know you've touched on quite a bit of this already. There's been testimony and there's been some argument about Ethan looking up or talking about going to prison. Is it normal that a 15-year-old would just be okay with the fact that he's going to do something that lands him in prison?
So teenagers go through a phase that is called personal fable. And if I may give you an example.
Sure.
A teenager may be driving 100 yards away, the light is about to turn red. They think that they can magically beat that red light and nothing bad is going to happen to them. It's because their brain, their prefrontal cortex, this is the brain supervisor, is not fully developed. Just biologically and physiologically, the human brain, the prefrontal cortex, is not developed until about age 24, 25. In Ethan's case, he has what is called arrested development.
Can you explain what that is?
Absolutely. So chronologically, he may have been 15 at the time, but given the high levels of stress and complex trauma, his age was much younger than his chronological age.
You've been able to see through the text messages and actually in your interviews with Ethan, he reported that he was not sleeping and he was not eating. How does that tie into mental illness?
So the brain consumes about 20 to 30% of the calories that we consume. So whatever we consume, the brain consumes about 20 to 30% of that. So sleep deprivation and lack of appropriate nutrition greatly impact the body. Our bodies were not meant to be in a state of high anxiety perpetually.
You've also been able to take a look at the Google searches that he was doing. And a lot of them are looking kind of for self-diagnosis, looking up what is depression? Do I have ADHD? Do I have obsessive compulsive disorder? What do you make of that?
So here is a child who was just trying to make sense of his inner world. He couldn't get help from his parents, from the home system, couldn't get help from the school system. He couldn't get to a doctor. He couldn't get to a counselor. So his last resort was to try to figure out what's happening to me. Is this normal? Am I depressed? Am I anxious? Am I a sociopath? Who am I? He's trying to make sense of what's going on within him.
You've also been shown a number of searches that were done on a particular website where very violent videos, actual murders, actual shootings are categorized and people can view them. What is your understanding of what that does, especially to an adolescent's brain?
So during adolescence, the person's brain is still in the formative stage. The neurons are still trying to connect. And if one spends an inordinate amount of time ingesting that type of content without supervision, before long, it's natural to lose sight of what is real and what is not real.
Now, you've been made aware that there was a situation at the jail with a password in a tablet, correct?
Yes, ma'am.
Okay. And can you explain what you believe to have happened in this situation?
Certainly. So Ethan was given a tablet, and because he's a fairly intelligent person, he was able to figure out the password and was able to go on the internet and use his tablet. And what he indicated to me is that although he had the urge to go to the live gore sites, he was able to restrain himself, which he's pretty proud of. 2 weeks, just did not go to the site, but he eventually went there.
And what does that, can you give that a context? What does that mean to you? Is he regressing? What, can you give an explanation to that?
So when you make a comparison of what he was doing prior, he was ingesting that content constantly, every day, hours and hours at a time. And in my mind, it's progress, not perfection, but progress.
Were you able to view the videos of Ethan killing baby birds?
I did.
Can you discuss the significance of that and what you think and how you think it fits into this case and his diagnosis?
Absolutely. I observed Ethan torturing baby birds. He wanted them to feel the pain that he was feeling inside. And I observed his persona. He was actually speaking to them in a different tone of voice, almost as a parent talking to a child. It's just a reflection of
Another baby bird so that he can kill them. Can you explain that?
it sort of lines up with my testing of his brain. I indicated that his obsessive compulsive scales, I think his score is 8-1, indicating that this part of the brain, the cingulate gyrus, is on fire, meaning that it's hard to turn it off, and without appropriate intervention, without treatment and medications, that part of the brain is stuck on.
What about the fact that when the police come in, Ethan surrenders, and then in the police car acts normal? I mean, he's not talking to voices, he's not flailing about. Can you explain that?
Certainly, it's a phase called tension reduction. So tension is something that is built up. Anxiety, obsession, anxiety, obsession. I guess a good analogy is to think in terms of like a pressure cooker. It's on the stove and it's boiling, and there's tension building up in there. And the one way for that tension to go away is when you release that knob, the tension goes out and you revert to equilibrium. So tension reduction cycle.
So is your explanation then, once he carried out this plan that he was so fixated on, he had that sense of reduction or accomplishment?
Absolutely, it's analogous to what we just witnessed. So the person in the videos is the same person in the courtroom. There's no difference. It is the same person.
I want to talk about the report that you authored. Obviously, in giving the history that you did, you've been doing these regular types of analysis outside of the courtroom for many years. You would agree with me?
That is correct.
Okay. So how is it that you came to start?
So I think it was around 2019, an attorney reached out to me and asked me if I would do one of the Miller hearings.
Mhm.
And I was fairly confident in my ability as a psychologist, in my ability to clinically interview someone, in my ability to test someone. But in terms of crafting a legal report, I was a neophyte. It was not my area of expertise. And so I reached out to the attorney and said that if I'm to do this report, I'm going to need you to reach out to your sources, obtain copies of their report, make sure you get their permission, because I plan to use the rubric and extract some of the legal language in my report. And that is 2019 to 25 clients ago. And that is the exact format that I've been using.
And that's what you did in this case?
Yes, ma'am.
Were you able to form an opinion whether or not Ethan Crumbley was mentally ill on November 30th of 2021?
Yes, ma'am.
And what is that?
He has major depressive disorder with psychosis, anxiety, and features of obsessive compulsive disorder. He is mentally ill.
And all the testing that you did and the interviews, do you believe that there's the possibility of rehabilitation?
I do.
And can you explain that?
Certainly. As I indicated, I've worked in the field of brain injury for 25 years. I take pride in my work. I've treated people with stroke, CVA. I've treated people with anoxic brain injury, and I've treated people with mental health. And along with my team, we have been able to rehabilitate people. A number of my clients have had issues with the law, and through psychotherapy and support, they've made progress. Additionally, and this is important, in neuroscience, there's something called neuroplasticity, and that is the ability of the brain to create new pathways to generate new neurons. You see this in stroke victims. It's a stroke on the left-hand side, it's right-hand side neglect. Well, those are the people that I've worked with and taught them how to speak again and how to walk again and how to function. So absolutely, yes.
So people with mental illness, especially ones that do something, extremely serious, that leads them down a path that they find themselves in prison. I know Dr. Keating touched on this a little bit, but you believe that, especially based on Ethan's age, that his brain can rewire and he can stop the behaviors that he was exhibiting previously. Is that correct?
That is correct. Ethan's brain is still maturing, and his brain probably will not reach full maturity for another 10 years.
Are the clinical opinions in your report based solely on the testing and your interaction with Ethan Crumbley that you yourself performed?
So my conclusions are based on my clinical interview of Ethan Crumbley and are based on the results from my testing.
I have no further questions. Thank you very much.
Thank you, Cross.
Your Honor, the doctors actually testified to a whole lot of things that are not in his report, and can we take a short break before cross-examination?
Sure. We'll go ahead and take about a 10-minute break. Deputies, if you could, go ahead and take the defendant back downstairs. To those in the gallery, please be seated until the defendant has exited the courtroom. Thank you, sir. You may step down.
Thank you, Your Honor.
We will stand in recess for approximately 10-15 minutes. Court stands in recess.
All right. Have you some business?
injuring 6 others. I want to go ahead right now and bring in legal expert Andrew Lieb, a friend of the show who joins many a times to talk about all of these things that are happening. I really want to break down, Andrew, really what it means to have a Miller hearing, because this is something that folks maybe haven't heard before. My understanding is this is a special hearing that has to do with, is that 8th Amendment rights?
You did great. Like, you should be an attorney in my office there, the way you jumped into 8th Amendment, which, by the way, is about cruel and inhuman treatment. And the Miller hearing is from a Supreme Court case. To what it is, I need to point out that this is not undermining anything that this guy pled guilty to doing. These murders are outrageous. What he said with terrorism, crazy. But this is a whole procedural issue that we need to understand just as society. This is how our government works. A Miller hearing is from this case from 2012. Miller v. Alabama. And it says when someone's a minor, this kid Crumbley is 17. You can't just sentence them. You have to have a hearing. And consider their age, and you have to consider their maturity, and say to yourself, are there circumstances where this kid could be rehabilitated, or throw him in jail? And right now the judge is taking testimony and hearing from both sides so the judge can make an informed decision.
What do you make right now? The video is being played. This is the first time anyone's seeing it publicly. This is obviously the video that likely shows him walking through the hallways of his high school and killing his classmates with a firearm. He's looking down. What do you make of that type of reaction to something like this?
Well, I'm a parent. I have kids in school, and just walking through the halls of the high school with a gun, it triggers me. I have to tell you. And that's not a Second Amendment thing or people having guns thing. I don't want to go into that. But there's no place for a gun, maybe in a shooting range, but there's no place for a gun through the halls of the high school. And you had me at that. What is this kid doing? And apparently his parents bought him the gun, and he's going in Crumbley, and this graphic stuff of his face going down. I don't understand it. I just can't comprehend it. I'm not a psychologist, but as a parent, I'm just thinking to myself, my worst nightmare is hearing that there's a person with a gun walking through the halls of the high school. So my emotional reaction is throw the book at him. But as a judge, the judge in this case, knowing about Miller v. Alabama and the Miller hearing, it's not just about what he did. It's about his age when he did it. What was the impact of why he did it? Like I said, his parents bought him the gun. What is the circumstances around him? And is there a time that maybe in his future he could be rehabilitated? And it's so hard as a human to separate emotion from analysis. But this is an analysis hearing. So I want you to separate that in answering the question.
Absolutely. Right now, the judge has to decide whether or not someone who committed a crime that they pled guilty to when they were 16 years old is eligible for life in prison without the possibility of parole, which obviously means that you go to prison for the rest of your life and there's no opportunity to get out. Obviously, a serious thing that the Supreme Court has certainly examined before. I know that case stems back to 2012, something around that, the Miller case, of course. Now, the prosecutors obviously arguing in favor of this, the defense arguing against this. They don't want to see their client in this case go to prison for the rest of his life, saying that he had mental health issues, as well as what they called a quote abhorrent family life. Do you think that's going to sit with the judge at all? And how do you think a judge may react to something like that, given what he's already pled guilty to?
I want to loop back to my previous statement and tell you judges are humans, and it's abhorrent. It's terrible. What happened, what he pled guilty to from when he was 16, he's 17 now. I don't have words for what he did. But the question is, and this is a fundamental question, let's get away from the case for 1 second. Is the purpose of our criminal justice system strictly for punishment and deterrence through punishment? Or is the purpose of our what's our goal here? What are we doing here? Is our goal to give people a chance and to rehabilitate? What you do when you're 16 may not have impact on who you are at 70. So the judge is looking for propensity. That means, are you the type of person that's going to do this again? Are you a danger to other people around you? Are you just someone that we should lock the key, turn away the key, and throw it out? So I think it's much more than this prosecutor, this Karen McDonald saying, and much more than what this defense attorney, this Paulette Lufton is saying. I think it's more about, is this a rehabilitation chance? Is there a chance that parole and society could benefit from him? Or is this a throw away the key? There's no rehabilitation from what someone does as a minor. And I have to point out, people aren't developed at 16, they're influenced at 16. So it's a tough decision for this judge, and that's why we expect multiple days of hearing moving forward.
Yeah, I know the judge has allotted at least 2 days for this case, obviously, and that doesn't necessarily mean that'll be the end of it too. Is that correct? Or will the judge have to make a decision by the end of these 2 days?
No, the judge can do whatever the judge wants. And I'll tell you a story from when I was in court just recently, which is interesting. I had a client that flew out of town and it was 4:25. The courts closed at 4:30 and the client was testifying. He probably had 10 more minutes of testimony. And the judge said, you know what? The court officer's got to go. Come back tomorrow. And my client looked at me like, I'm nuts. Why are we got to come back tomorrow? I flew in from out of town. I got to stay in a hotel now for 5 minutes. And the judge said, I'm not satisfied. I want more. And this is a government job, municipality. It's not just me. I could stay late, but there's court officers. I got to send them home. So the judge could say into next week, the judge could keep going. And I think that's a good thing. I think it's good as a society that in this case, the judge is going to want to be thorough. Maybe the judge is going to find the findings by the end of those next 2 days. Maybe not. But this is a very tough situation to decide because emotionally we say lock them up, throw away the keys. This is gone. We can't have this in society. Awful, awful, awful. And we need a deterrence. But when you speak to the social scientists, sometimes the deterrence like that doesn't work out the way you think it's going to, number one. And so, number two, a 16-year-old doesn't have the brain that's fully developed, and the influences of the parents getting the gun, what's going on here? What were the triggers? This is a tough situation, and I feel bad for the judge more than anyone else to make this decision, whether there's a cruel and inhuman punishment under the 8th Amendment to say, listen, we should lock them up, throw away the keys. So as a parent, lock them up. As the judge, I'm glad I don't have your job.
Yeah, an incredibly challenging decision given what's happened here. And, you know, regardless of the guilty plea, they have a lot of evidence to kind of go over. Obviously, I imagine that the defendant, Crumbley's reaction in this may also be something the judge looks at. Do you think so?
I do, but I'm reading a book right now that I think is kind of interesting. It's called Talking to Strangers. It's from Malcolm Gladwell. And he actually goes over in the book about reading facial language and how people respond and what we're thinking is actually not a predictor, even though we as a society thinks it is. Meaning, I think the judge is going to be swayed by this defendant, by the remorse shown, by what's going on, where the body language is. But maybe he's just a good actor. And so I would hope the judge focuses more on the facts and the evidence than how the defendant appears and what his story is. I want facts and evidence about the circumstances because, like I learned from this Malcolm Gladwell book, I'm very interested not in who's the better actor, the better manipulator, but what the evidence tells us. And again, that's another hard thing for a judge to do because we all know that when someone looks sad, they look like they're remorseful, we have an emotional reaction to it. So the judge needs to be able to control the judge's own emotions while evaluating the hard evidence and in a robotic fashion to some extent, deciding whether this is a life without parole or giving an opportunity. In no stretch of the imagination, though, just to be clear, is this kid getting out of jail anytime soon? This is a long jail sentence no matter what. The question is there an end date? That's all we got going forward.
I also want to ask about death penalty. Was that ever on the table in this case? And I might be throwing a curveball on you because I know you're out of New York and we're talking about Michigan state law here. But was that ever a possibility there?
I honestly don't recall to answer your question. To remind you that we have different states that have different rules about the death penalty. I would imagine, and maybe I'm wrong about this, is pure speculation, is that you wouldn't plead guilty with the death penalty on the table most of the time. So assuming just for argument's sake, that the death penalty was possibility there, and I don't know offhand, as you said, I'm in New York, whether Michigan permits it or doesn't permit it, I just don't remember. Assuming it was, I would imagine a defendant would only plead guilty with the fact that that's taken off the table. I would think that would be kind of insane for an attorney to allow their client to plead guilty when the death penalty is on the table. Usually that's one of the parameters in the guilty plea. That's why they don't plead right away. They say, listen, I'm willing to plead if, and that's what a plea is. It's a private contract between two people. I would imagine that's the case, but either way, in a cruel and inhuman punishment thing, assuming he did plead guilty and assuming the death penalty was on the table, we'd still be at this Miller hearing. And I think it would be hard pressed to find any judge to sentence someone who was 16 when they committed a crime to murder, because again, he's a juvenile. There's a difference in the brain development of a juvenile. And I would think that would be something we wouldn't ordinarily see. But when we look at what he did and when we think about as a parent, I don't know, you emotionally want the death penalty, but is retribution the best thing for society? I don't know these answers. Smarter people than I need to come up with them, though, because this is a real occurrence. These deaths in schools, it's a big problem. And I don't know why we hear about Trump and Hunter, and we hear about what's going on here and there. The number one issue I think that most parents want to hear is, how are you going to stop deaths in school, Congress? That's what we want, deaths in school. My kids, my son, my little one went on the bus to camp today. I put him on the bus. I can't fathom a world where we're hearing about an active shooter at his camp or at a school. It's insane that they haven't done anything about it. We need more and more legislation and more resources to stop this macro level in society. That's what people talk about on the kitchen table. Republicans, Democrats alike want no deaths in school.
And we do, Andrew, have a little bit of information just to follow up on that from the Death Penalty Information Center, just so we can kind of bring that back into the conversation. Only 13 executions have been carried out in the state of Michigan's history. Just 6 of those occurred after Michigan became a territory back in 1805. So obviously likely not something that would have even been really brought up in this case. That makes a lot of sense, as he did plead guilty, continuing to appear there as this looks like that trial is about to, that hearing specifically, maybe taking a pause, likely for lunch. They've been in court for about 2 hours now, but we're still waiting to see more about that. Meanwhile, Andrew, is there anything we haven't asked you? Anything that you'd like to add about this case?
I think you're hitting it, and I'm glad we're spotlighting it because, again, it's too frequent. They've all meshed together with me, all these cases. And I don't know that punishment is a deterrent in this situation, meaning if every active shooter knew they were going to get the death penalty in schools, we still have active shooters. They get shot all the time. They kill themselves all the time. The solution to gun violence in schools is certainly not the criminal justice system of punishment. There has to be a different solution, and maybe it's mental health. Maybe it's access to guns. Maybe there's more registry. I don't know what the solution is. But as a society, we have to say, hey, why is it so hard for us to remember? You know, you guys ring me and you go, hey, do you want to be on the show? And I say, yeah, I'll do it. Which active shooter case is this one again? I shouldn't be saying that. I should know specifically, oh, this is the one that they shot the first time in the last 50 years. It shouldn't be that it's such a mesh of times that which state, which one, how did this happen? Remind me again. And that's a major fail by all people involved in government, society, in our voting. And I hope we can take a pause. And thoughts and prayers are great. And I do give my thoughts and prayers to the families of these victims. But I can tell you, I'm certain they all want solutions that this be one of the last of these active shooters, at least not so frequently. So I think it's great that you're spotlighting it. And I thank you for having me on the show.
All right, Andrew Lee.
Yes. Good afternoon, Your Honor. David Williams on behalf of people.
Paulette Michelle Lofton on behalf of Ethan Crumbley. Amy Half on behalf of Ethan Crumbley. Deborah McKelvey on behalf of Ethan Crumbley.
Thank you. You all may be seated and good morning again. Dr. King, if he's still in the courtroom. Dr. King, you may retake the stand, sir. Sir, you may be seated. You are still under oath. Thank you, Your Honor. Thank you. People cross.
Good morning, Dr. King.
Good morning, sir.
Dr. King, you're here because your job is to help the defense establish mitigating factors for this defendant, correct?
Yes, sir.
And you're familiar with the Miller factors.
Yes, sir.
And in fact, you note that on the first page of your report, the defendant was referred to you for an evaluation focused particularly on the sentencing factors outlined in Miller versus Alabama, correct?
Yes, sir.
And then you say that the Miller factors and mental illness, you say supports a sentence of other than life without parole, true?
Yes, sir.
You know that the Miller factors are incorporated into Michigan law. Are you aware of that?
Yes, sir.
Okay. And can you tell us what the 5 factors are?
So, immaturity, age, person has to be younger than 18, impetuosity, transient recklessness, and ability to extricate oneself from a dysfunctional family.
Anything else, doctor?
I probably missed a couple. I didn't memorize them.
Okay, so doctor, in fact, under the law, there are 5 factors. First is chronological age, hallmark features among them, immaturity, impetuosity, failure to appreciate risks and consequences. Does that sound right?
That's about right.
So most of what you described goes to that first factor. The second is the juvenile's family and home environment. And you talked about that, the inability to overcome his circumstances, right?
Yes, sir.
There are 3 other factors: the circumstance of the homicide offense, the incompetencies of youth, which affect how the juvenile might have been charged or convicted of a lesser crime, and the possibility of rehabilitation, correct?
Yes, sir.
All right. Doctor, when were you retained in this case?
I think I was contacted on or around, and my timeline could be off. I want to say in November. It was just around Thanksgiving of 22, I believe. Again, my timeline could be off.
And you were provided some materials to review,
Yes, sir.
and then you interviewed the defendant.
I did.
Over how many sessions?
I believe over 6 sessions.
And can you tell us when those were?
Sorry, I did not memorize the date. I think the first time I met the defendant would have been around January 4th or 5th. I think that is the first time I interviewed him. I interviewed him twice virtually, and maybe 3 or 4 times after the last time I interviewed him was probably July, I think 10th or 11th. I don't have the access to my calendar, so I didn't memorize those dates.
Hey, Doctor, what do you have with you today? Before you move on, the first meeting you said that was on January 4th or January 5th, was that of 2023?
Yes, sir.
Thank you. And then your last meeting, of course, would have been in 2023 as well, sir?
Yes, sir.
Thank you. You may proceed.
Thank you. Doctor, what do you have with you today?
I have my PowerPoint and I have a copy of the presentation. I have my iPad. I have a model of the brain. And I have a copy of my CV, and I have a copy of my report that is highlighted.
Could you take out your report, please?
For the record, his report is also in Defendant's N, is that correct?
That is correct, Your Honor.
Thank you.
Extra copy.
So, Doctor, can you have your report in front of you?
I do.
And so we're clear, that's your report dated June 16th, 2023, and you signed it on page 69, correct?
I do.
All right. If you turn to page 3, Doctor, does that help refresh your recollection regarding any of the dates that you interviewed the defendant?
I do.
Okay, so was your first meeting with him on December 15th of 2022?
That is correct.
And you conducted a structured interview on January 23.
That is correct.
Okay, and as to the other 3 dates, you're not able to give us those today.
Yes, that is correct.
And Doctor, you did some testing and then you did some research yourself, correct?
That is correct.
Doctor, in the timeline that was in the presentation that was put up on the screen, it didn't include the dates of your reports. You prepared 2 reports, correct?
I prepared an initial report because if my memory serves me correctly, this hearing was supposed to have been held, I think, early in May.
May 1st.
May 1st. And then I was told that there was an adjournment, and so here we are today.
Right. Okay. So, but in your timeline, it didn't include the dates of the reports. And in fact, the first report came partway through that timeline. Would you agree? And then the last report came in June.
That sounds about right, sir.
So, Doctor, on page 3 of the report, again, we're talking about your June report. You referred to on page 2 as a complete list of records relied on and reviewed, correct?
What page is
On page 2, you reference in the first paragraph, partway down, a complete list of records reviewed and relied on is listed beginning on your report. You list a number of things, correct?
That is correct, sir.
Dr. King, you testified to a number of things on direct that don't appear in that list. Can you tell us what those are? What other things that aren't on this list you reviewed and considered?
So, for instance, Dr. Kadir's report from Easter Seals, which was comprised of 1,310 pages. I believe I only got those, I think, last week. And Ms. Lofton, of course, has sent me updated information. I apologize, I've not been able to memorize information. We're talking about voluminous pages of information.
Okay, so what I want to know about, doctor, is things that you had at the time of your June 16th report that you did not list. So, for example, you said in your direct testimony that you interviewed a neighbor. You recall testifying to that?
Yes.
And that's listed in your source of information.
That is not listed here. I do not see it here.
Okay, in fact, when did you conduct that interview?
Probably it was about, I think about 2 months ago, and again, my timeline could be off. I don't have my calendar in front of me, sir, so I'm not able to give you that exact date.
Doctor, you made no reference to that in your report, did you?
It's not in my sources of available information.
Is it referenced anywhere in your report?
I don't see the reference here, sir.
I'm not, there are a bunch of things you referenced that aren't listed in your sources, and we'll talk about that. What I'm asking you is, did you make reference to your interview with the neighbor anywhere in your report? Is there any way I would have known that about that before today?
Yes, so, can I explain?
Please.
So you have, sir, a copy of my PowerPoint?
No, sir, I don't.
I apologize for that. I did.
And do you have that documentation with you today?
It's not in my report, sir.
Okay, thank you. Do you have documentation of that anywhere? Do you have notes? Did you write a short report? Did you report that to council? Do you have anything that reflects your interview with a neighbor?
Yes.
Okay. Do you have that with you today?
I do not.
Doctor, you also referenced text messages between the parents, right?
Yes, sir.
And that's not listed in your source of information either, is it?
It is not listed.
Okay. And you don't reference that in the report, do you?
That is correct.
Doctor, you testified about reviewing the something about a dog, right? About bringing the dog.
That is correct.
Okay. You talked about researching how to do that. And that's the same shed where he tortured the baby birds, correct?
I don't know that to be a fact, but if you say that is the case, I don't know that to be a fact.
So, doctor, you have something that no one else in this courtroom had. You had access to all the information you wanted, and you got to interview the defendant. Did you not ask the
So please, I don't know this multiple sheds. I've never been to the home, sir, so I honestly don't know.
So, doctor, I just asked you about the torture, and then you said the torture of what? Are you aware of torture of anything other than birds?
I just wanted to have clarification from you, sir, just before I answer the question.
That's fine. Are you aware of any other torture committed by the defendant?
Besides the birds, I don't think so. Or at least I don't recall of any other.
Doctor, you also mentioned that you reviewed text messages over a period of months between the defendant and his friend B. Is that right? Is that your testimony?
Yes, sir.
In your report, doctor, you reference a subset of those, right?
You have a page for me?
So Doctor, you can do two things. One is, why don't we look at page 3? The fifth bullet point up from the bottom, and you list the series of dates. Text messages obtained by Paulette Lofton between the defendant and his friend B dated April 5th, 2021 to April 7th of 2021, right?
Okay.
But you're telling the court, you in fact reviewed a lot more text. You just don't reference some of your sources, correct?
That is,
And then Doctor, on pages 8 through 22, 8 through 21, you include a series of text messages. You know about how many those are?
how many text messages?
Yeah, that you include in your report.
Oh.
If I say roughly 200, I don't need an exact number. Does that sound about right?
I would not disagree with you. Okay.
And Doctor, you'd agree with me, those text messages that you specifically paste into your report are all from one day, April 5th of 2021.
As far as I can see, sir, yes.
Doctor, you looked at some emails, and then you looked at something, an assignment from Mrs. Kubina that you referenced. Those also are not listed in your source of information, are they?
They're not.
But you did review them and consider those.
I did.
And then Dr. Aniker's report is listed in your sources, correct?
That is correct, sir.
And you reviewed that entire report, correct?
The report of Dr. Aniker?
Yes.
Yes, sir.
Okay. And you considered that in your analysis. It was part of your review and your conclusion. Is that correct?
I did.
So doctor, we talked about the text message you reviewed. You also reviewed some videos, correct?
Yes, sir, I did.
What videos did you review?
I reviewed the videos of the actual shooting. I reviewed the videos of the bird. And the video of Ethan taking a fall in the diner. And I believe 4 or 5 other videos from the Oakland County Jail.
Okay, and doctor, do you also review the video that the defendant took the night before the shooting?
Yes, I did.
Doctor, regarding the diner video, when I watch it, it doesn't seem you can see in the video whether the defendant hits his head or not. Were you able to see that in the video, or did you get that from the defendant?
Can you rephrase that question, please, sir?
When I watched the video from the diner, I actually didn't see the defendant hit his head. Maybe I missed it, but are you saying you can see that in the video, or that that's what the defendant told you?
I'm wondering if you missed it, sir, because based on my review of it, that is what appeared to have happened, and he was helped up, and then he fell again and had to be helped up. That's how I saw it.
You prepared, we talked about 2 reports, doctor, and the first report is dated January 7th, 2023. You know, may I approach, Your Honor?
Yes.
Doctor, I'm sure the people exhibit 63.
One moment, sir.
Doctor, I'll go through that with you a little bit, but does that look like your previous report?
It does. I do have an updated report, June 16. So these two, this is an updated of what I did initially.
Correct. So I received 2 copies of your report. The first one is the one you're looking at now, Exhibit 63, and the other is the June 16th report. And that sounds right to you? You did 2 reports.
Yes, sir.
Okay, and you agree this is the first one?
Yeah, so I'm a little confused because I'm under the impression that the June 16th report supersedes the June 17th report because the June 16th report has information that I didn't have when I did the January report.
Okay, that's important, Doctor. It's information you didn't have, and we're going to talk about that. All right, Doctor, are there differences between the two reports?
Yes, sir, there are differences.
Can you tell me what those are? You know what, Doctor, I want to step back for 1 second. We'll withdraw that question. We'll come back to that. Do you know when that report was finalized? Because it's dated January 27th, 2023. I didn't receive it until April. Do you know when you finalized that version?
So I'm not able to keep that timeline in my head. I apologize that I can't memorize the timeline of the report was completed, sir.
So, Doctor, I'm not worried about memorizing the timeline. I'm just asking if you know about when this. So you agree you were going to testify on about May 1st for the Miller hearing when it was originally scheduled, correct?
Yes, sir, that is correct.
So did you complete your first report in January, a few months before the Miller hearing, or did you finish it in April or sometime in between?
I know it was completed before May 1st, but exactly when, I don't know, sir.
Okay, a couple weeks before?
Okay.
Okay, so when you submitted that report at that time, you thought that was your final report and you were going to come to court and testify on May 1st with that report, correct?
That was my understanding, sir.
And at that point, you
In November. And
okay. And at that point, Doctor, had you been given access to everything you needed or you wanted to see for your report?
I was given access to information. I don't know that I was given access to everything because obviously since then, I've been given additional information.
Okay. And at that point, Doctor, if you look at your first or the partial paragraph at the bottom of page 1 of the January report, said you'd spent 16 hours interviewing the defendant, correct?
That is correct.
Okay, and then after you submitted that report, this hearing was adjourned, right?
That is correct.
And then you spent about another 6 hours with the defendant. In your June report, it says you've spent now 22 hours. Does that sound right?
That sounds about right.
All right, Doctor, I asked you about the differences in the report. Can you go over those with me?
Are you asking me to tell you the differences in these 2 reports?
Yes, sure. Yes. Doctor.
I'm not sure if you want me to go through page by page. So their first report has 6 to 9 pages. And I think my
Your second report also has 69 pages, Doctor.
Nine pages. So what parts do you want me to go through, sir?
I'd like to know what you changed between the January report and the June report. All right, so Doctor, as you sit here right now, you're not able to quickly tell me what changed.
Yeah, we're looking at almost 70 pages or single spaced
it will take me a long time to compare these two reports and go through line by line by line.
Would you agree, doctor, there are not a lot of differences? Would you agree with me?
I am not able to answer that question, sir, because I don't know the answer.
Okay, but they're both your reports, doctor, and you had an additional couple of months when the hearing was adjourned to prepare another report, right?
Yes, sir.
And you're saying you don't remember what you did in addition to your first report. To come to your second report. Spend another 6 hours with him, right? So doctor, look at
Before
the,
we move on, did you meet with him for 6 hours through May and July?
Approximately.
Thank you. You may continue.
so doctor, I want you to look at page 1 of your June report, and I want you to look at the second sentence. Starts on December 1st, 2021. The defendant was booked at the Oakland County Jail after bringing a 9mm handgun to Oxford High School, where he allegedly shot and killed 4 of his classmates. Do you see that?
Are you reading from the January report?
June report, doctor.
Oh, I'm sorry. Can you repeat that?
Yes, I want you to look at the June report and see that you said that the defendant allegedly shot and killed 4 of his classmates in June. You see that?
Yes, sir.
In fact, in your January report, you don't say allegedly. Can you tell the court why you changed it to say that he allegedly killed 4 students?
I don't know why that was changed, sir.
No one has ever told you that this defendant did not kill those 4 students, correct?
That is correct.
You know that he did it, but for some reason you made a change to say that he allegedly did it, but you don't know why.
That is correct, sir.
All right, doctor, I'm looking, now we're going to go back to the January report. I want to look at page 3 of the January report, and I want to look at the items you considered. Sources of available information. From the January report, I'm looking at the last bullet point. Judge, I'm sorry, I don't know if I gave you a copy of People's Proposed Exhibit 63. May I do that?
Yes, are you moving to admit it at this time before the
Yes.
court reviews it? Any objection?
No objection.
Thank you. Plaintiff 63 is admitted. You may approach.
Thank you.
Thank you.
All right, so doctor, we're looking at the last bullet point on Exhibit 63, the January report. In the last bullet point, can you read that to us?
On the January 27th bell, that is dated January 27th. The last bullet point says Oakland County's Prosecutor's Office video footage.
Correct. And you list 3 videos, correct?
I do.
And what are those?
It's the Oxford High School video of 11/30/2021 shooting. Third video recorded by Ethan. And then I have manifesto recorded by Ethan.
All right, doctor, now I'd like you to turn to page 3 of your June report.
I'm looking at the June report.
Okay, and the last bullet point, what does the last bullet point in the June report say?
Says Oakland County deputies body camera footage.
And in that regard, you're talking about the body camera footage from the jail that we saw on the screen, correct?
Okay, I think so.
Okay, he's wearing the spit hood over his head and they've got him in a chair. He's upset.
That is correct.
All right. So, doctor, you did in fact view the Oxford High School video of the November 30th, 2021 shooting, the bird video recorded by Ethan, and the manifesto video recorded by Ethan, right? You had access to those and you reviewed those, correct? Correct.
That is correct.
And then you just took them out of your June report.
I don't know that I took them out.
Doctor, you're welcome to as much time as you want, but if you look at that list on page 3, those videos are not referenced.
Yes, they are not listed here.
Okay, so you took them out, and my question to you is why?
Sir, they're not listed here.
And my question to you, doctor, is why aren't they listed? Why did you take them out between your two reports?
I'm not sure why.
But you agree with me, you watched those before your January report.
Can you repeat the question, please?
You watched those videos before you submitted your January report. So when you listed them in your sources, in your January report, you had in fact reviewed them.
That is correct.
Doctor, on page 49 of your June report, so page 49 of your June report under events leading up to the shooting, do you see that?
Yes, sir.
And you referenced the journal that the defendant kept. Do you see that?
You're on page 49.
Yes. The first line under events leading up to the shooting.
Yes, sir.
When did you review the journal?
What date?
Yes.
I don't have the date in front of me, sir.
But when did you receive it from counsel?
I don't have that exact date in front of me, sir. I do not know the date.
I want to jump ahead to page 68 of your January report. I look at conclusion events. And we're on page 68. Do you see that?
One moment, sir. Yes.
Doctor, the last sentence, I'm sorry. The second to last sentence under conclusion event says, surveillance video shows the defendant sitting on the ground crying, fully well knowing that he is on a path of no return. Do you see that?
Yes, sir.
That's not in your June report, is it? It's page 68 of your June report. It's at the top. It's conclusion events and sentence is taken out. Is
On the June report,
correct.
it says surveillance video shows Ethan sitting on the
January report, correct?
That is correct.
But not in your June report, correct?
I actually just read that from my June report.
And doctor, you and I have two different reports. Can I see what you're looking at, doctor?
Certainly. May approach the witness.
Your Honor, may I approach and provide my client with a copy of the report that is contained in my exhibit? I don't know if the report that he's referencing is another edit that was done, but I have the copy that was submitted to the people and that was submitted to the court. He was not provided that copy today, so I don't know if he's looking at another version.
Thank
And
you.
I'll just indicate for the record, Your Honor, he showed me a report that's dated June 16th, but the language is not the same.
Thank you. Are there multiple copies of the June report?
This was a working document. I know over to the was turned over to the people as well as the court to make sure that we are all looking at the exact same version of this report that is ever changing.
Thank you. He should only have the report before him that has been admitted into evidence. And so whatever's been admitted into evidence, doctor, that's the only report that you are to be testifying to. Please don't testify to reports that have not been admitted into evidence because it causes confusion. You may approach the witness and give him the exhibit that has been admitted into evidence.
Thank you.
Thank you. And what's the date of this
It
exhibit?
is the June 16th report.
Thank you.
Thank you.
People, you may proceed.
Thank you. Your main approach, I'd like to see what he brought to try and understand why there are two reports with the same date and different data. My approach.
You may.
May I also approach?
Yes, absolutely. And counsel could take a moment to compare.
That's. Yeah, you take it out, please.
Yeah, that's the one that was the one that was used as an exhibit.
Thank you. All right, so first, Dr. I want to make sure we've cleared this up. So you came to court today and brought a third version of your report that is in fact dated June 16th, but is not the final version. Is that correct?
So as attorney explained, this has been a work in progress that I've emailed and sent over and updated. So there seems to be some confusion as to which one is current. I've been handed a copy of what I think has been admitted into evidence. And that's the one I'm referencing.
All right, and now, doctor, I'm going to bring back to you the one that you brought with you to court today. And what I'd like you to do is now turn to the report that's been admitted as an exhibit, the June 16th report that's in evidence.
Okay.
And if you flip to page 68. Okay. And if you look at conclusion events, you see that the sentence I referenced in your January 27th, 2023 report, and that's still in the report you brought with you, is in fact not in the report that was provided to me, and that's in evidence today. You see that?
That is correct.
Okay. Doctor, where did that come from? The statement that surveillance video shows the defendant sitting on the ground crying, fully well knowing that he's on a path of no return. Where did you get that?
I had an opportunity to view the video of him sitting in the lunchroom, the cafeteria.
So, doctor, that's your interpretation of a video of the defendant. You say he's crying.
Okay,
There's no audio.
there's no audio.
Did you ask the defendant about that?
I did not.
All right. So, doctor, between the first report and the second report, we're going to say you got about 2 months more to time to work on it, correct?
That is correct.
And based on everything you reviewed and your discussions with the defendant and with his defense team.
That is correct.
And you included the mitigating information you found in your report, correct?
That is correct.
And in fact, that was the whole point. That's why you're retained, is to find as much mitigation as you could and then present that to the court in a report and then come testify about it, right?
That is correct.
And doctor, you were given sufficient time to meet with the defendant and consult with defense counsel, right?
That is correct.
And you weren't rushed in doing your report,
I don't think I was.
okay? And if you felt there was some more mitigating information out there in the world, like you talked to the neighbor, if you thought there was something else, you would have looked into that, correct?
That's correct.
Was there anything, doctor, that you saw referenced in anything that was provided to you or that you learned from the defendant and you said, you know what, I haven't seen that, I would like to see that? Anything that you wanted to see that was not provided to you?
Okay, correct.
I'm asking you, was there anything in addition to what you have that you said, I would like to see something else that was not provided to you? Were you given everything you asked for?
As far as I'm aware of.
All right, doctor, we're going to spend some time on your June 16th report, but before we review that, doctor, did you listen to the testimony presented by the prosecution last Thursday and Friday?
I did.
Okay. And you've never spoken to any of the investigators in this case before, correct?
I have not.
And you've not spoken to Keegan or Heidi or Ms. Gibson Marshall or Ms. Darnell, the witnesses who testified who were in the school, right? You've never spoken with them.
I have not.
Okay. So when you heard their testimony, doctor, did that have any impact whatsoever on your opinion?
It hasn't changed my opinion.
Okay. All right, doctor. So now I'm going to focus on your June report, and I want to turn to page 4. And in the section under Ethan, family tree, and early influence, you represent ACEs, right? We're on page 4 of the June report.
That is right.
All right. And doctor, you don't reference the study that you're talking about there. You provide a footnote at the bottom, but it doesn't give me a journal or a place to find that specific report. Do you have a site for that with you?
Can you rephrase that, please? I'm not sure what you're asking me.
All right. So if you look at your footnote 2 on page 4, you talk about the adverse childhood experiences study, child abuse and public health, but there's no citation. You list some authors, but I wasn't able to find that specific report. Do you have a citation? Some way to find that specific report?
So just for clarification, in my testing, the ACEs consist of 10 questions. And the more ACEs that are present, the more the probability exists that this person is going to have issues. In my more than 16 hours of interviewing Ethan, I obtained the ACEs information from him. So if you're asking me, did I administer the ACEs? There was no need to.
Okay, but
the question is for this footnote, do you have a specific citation for this footnote that would help aid in trying to find this article?
The citation is listed there where it says the adverse childhood experience study, and the author, Dr. Robert Ander, from the Center for Disease Control.
and what I'm telling you, doctor, is I Googled that. I tried to look it up, but without a citation, I was not able to find that specific report. And I'm asking you if you have a citation so I could reference the exact report you're referring to.
This is what I looked at, sir, in terms of the ACEs coming out of the CDC.
Do you have a copy of that, doctor? The report you're referencing in footnote 2?
I don't have a copy with me. I looked at a study coming out of the CDC and Kaiser pertaining to the ACEs.
So, doctor, I think this was in your slide, but that study looked at the adverse health effect on the child, right? In this case, the defendant, not on, so the things they would experience later in life because of the ACEs, right?
That is correct.
Health effects and heart problems and stress and all these things, right?
That is correct.
The reason I'm asking for the study is because in your description on paragraph 4, you say that that ACEs culminate in numerous antisocial activities such as aggressive acts, unwarranted violence, and heinous crimes. And I couldn't find that anywhere in relation to ACEs. And I'm asking you, where do you get that from?
Sir, if you were to research and look at information surrounding the ACEs study, I think it was 95 and 97. My dates could be off of 17,000 subjects. There is a litany of information in terms of what happens to someone who possesses these X amount of ACEs.
And so the problem is, doctor, you can't give me that report. You can't cite that to me so I can question you about that.
Okay.
So doctor, you talked about a 10 question survey. And in fact, you just said you didn't need to score him. You didn't attempt to score him, did you?
I did not administer the ACEs because I administered 15 psychological tests that provided me the information I needed to reference the ACEs.
All right, doctor. So you say there's studies out there that can trace an ACEs score to other effects, but you didn't need to give it to trace it to other effects. You had other testing. You don't need ACEs. That's your testimony.
I got that information from testing Ethan over 15 different test and screening measures.
All right. And so how hard is it to give someone an ACEs score? Ask the 10 questions.
Actually, it's not difficult at all.
Okay, but you didn't do it.
There was no need to.
All right. And you agree with me that in fact, you need a score of 6 or more to be predictive. That was your testimony on direct, correct?
So what I said was 6 or more can predict. It's a predictor. It's not a precise screening measure that this person will have these type of problems.
Doctor, you relied largely on the defendant's self-reporting for a lot of your analysis, correct?
No, that is not correct.
Okay. Let me ask you this. You're aware that he has said that he was not bullied, right? You're aware that he said that?
That is correct.
And that he thinks that he had an okay home life, right? That's his opinion.
That's his opinion.
Right? You know that he didn't suffer any sexual abuse, right?
I'm not aware of that, sir.
Physical abuse?
That is debatable.
Okay. So doctor, can you, as you sit here today, can you tell the court that in fact, this defendant has a score of 6 or higher on ACEs?
Absolutely.
All right. So you can score him on ACEs right now.
100%.
Okay, let's do that.
Absolutely.
Take me through the testing, take me through the 10 questions, and let's talk about his score.
So I don't have the question in front of me, but I can ask some of the questions to get the information to that question. I'll be happy to walk you through.
Okay, please.
Okay. You want to ask about
Doctor, so we're clear. I don't care what you want to ask about. I want you to tell me the defendant.
and I said I did not have ACEs. I said I can give him an ACEs score based on the 15 tests that I administered.
All right, doctor. So why don't you give me his ACEs score based on the 15 tests you administered?
So his score will probably range somewhere between 6 to about 8.
And that's based on the other tests that you gave him.
Yes, sir.
And that's not anywhere in your report. You agree?
I did not administer the ACEs.
Doctor, on page 6 of your report,
Before we get too far from this issue, there was something I wanted to clear up. When the prosecutor asked you about physical abuse, your answer was debatable. What did you mean by that?
Sir, if a child is injured and the parent does not take action, that is considered physical abuse. When Ethan fell in the diner and hit his head, and the owner said, I need to call 911 and didn't, I consider that physical abuse.
all right. So
Before you move on, is that the only thing that you consider as physical abuse as it relates directly to this defendant?
Additionally, when Ethan was with his parents and fell again and reported a loss of consciousness and was not taken to seek medical attention, I also consider that to be physical abuse.
Thank you. People, you may continue.
Thank you, Your Honor. On page 6, Doctor, in the last sentence of exposure to violent scenes, you make the statement, quote, "This mentality is typical of persons who spend an inordinate amount of time ingesting violent content." You see that?
Page 6, what paragraph?
It's the last sentence under exposure to violent scenes.
Yes, sir.
Doctor, you don't cite anything for that, do you?
There's no citation here.
Okay, what do you base that on?
I base it on my clinical experience, sir.
Doctor, I mean, that's been studied, hasn't it?
It has.
It's been largely debunked, isn't that true?
That is not true.
Okay, can you cite me anything? That substantiates that.
I'm happy to respond. So it's hotly debated as to whether if one is exposed to frequent scenes of violence and carnage, if that exposure has an adverse effect on that child. Some experts say no, and some experts say yes. I can cite you Eric Erickson, developmental psychologist, who chronicles that between the ages of 0 to 5, a child learns most of his core values. In fact, children absorb what they observe.
So, Doctor, thank you for that answer, but the defendant's playing of video games actually post-dates this thinking, right? He reports having violent thoughts long before he played any of those video games. Isn't that true?
That is true.
Okay, so you can't have cause and effect where the violent thoughts are caused by the video games he played later. Would you agree with me?
Can you rephrase that question, please?
Having violent thoughts at age 5 or 6, and he plays video games at age 13, you would agree with me, the video games didn't cause the thoughts.
Sure didn't make them better.
Okay, so you're saying a person who already had violent thoughts was urged on by the video games he was watching.
What I am saying is that at age 6, if you're having aberrant thoughts and you engage yourself in frequent exposure to video games, it's not going to make you a better person.
We can agree on that, Doctor.
Thank you.
All right, Doctor, on page 7, you talk about mental illness, correct?
Yes, sir.
And you cite this, you cite the statutory definition of mental illness, and you also reference something you refer to as, quote, the Miller factor. Do you see that?
Yes, sir.
Doctor, which Miller factor are you referring to?
The Miller factor of 2012, or the Miller hearing of 2012.
So, Doctor, we walked through at the start of your testimony what the 5 Miller factors are on the United States Supreme Court. There are 5 of them. And what I'm asking you is, when you say in the last line of the first paragraph under evidence of mental illness, you say, taking into consideration certain factors known as, quote, the Miller factor. And what I'm saying is, when you're talking about mental illness, which Miller factor are you talking about?
The inability to extricate oneself from a dysfunctional family.
All right. So you're saying the second, his family and home life is where you would put mental illness.
His family and home life. Yes, sir.
Doctor, you say that the defendant, and this is in the last full paragraph on page 7, that the defendant is without question someone who is mentally ill. Do you see that?
Yes, sir.
And you base that on the text messages that you cite in the pages following and some testing you did, correct?
I based that on my clinical interviews. I based that on my testing using objective testing methods.
So I just want you to look at the sentence that follows that. It says, a review of his verbalization through text messages and psychological testing substantiate this assertion, right?
Yes, sir.
And then you reference a group of roughly 200 text messages, correct?
Yes, sir.
Doctor, the statutory definition of mental illness in criminal law relates to the question of criminal responsibility. Are you familiar with that?
Yes, sir.
Have you testified previously about criminal responsibility?
I have.
All right. And that has to do with whether the defendant has a viable insanity defense, true?
That is correct.
Dr. Aniker's report, correct?
I did.
And would you agree with me that it's a very thorough report?
I do not.
Okay, what's missing?
I looked at Dr. Aniker's report. And in all of my years of testing, and this is, of course, no disrespect meant, sir. I'm just giving a factual response to your question. Not one testing was done in Dr. Aniker's report. In Dr. Aniker's report, Ethan expressed hearing voices and seeing things. In Dr. Aniker's report, Ethan said that at age 6, he went up to the preschool person, and this is what he said: "Wouldn't it be cool if cars could just crash into this school and kill a lot of people?" And the person said, "Then why would you say that?" That is referenced in Dr. Aniker's report, sir.
Right, it is, exactly. Why is that a problem or something missing in her report?
So to conclude that such a person does not have mental illness is striking.
All right, so doctor, other than the absence of testing, anything else that you where you disagree that it's a thorough report?
It is not, sir.
Okay. Outside of the testing, what else do you think is missing?
So to diagnose someone with mental illness, there's 3 ways to do that. You look at the brain,
Which you did not do, correct?
I did not do.
Correct.
You test the brain,
Correct.
which I did, times 15.
Okay.
Then you use a cluster of symptoms using the DSM. That is the Bible or the Quran for psychologists. There is no evidence that that was done. And then the 4th way, which most people do, is to guess. I did not see 1, 2, 3.
Okay, doctor, you both didn't test the brain, right?
I'm sorry?
Neither of you tested the brain. You've agreed with that. You didn't give him an MRI. Neither of you did. Neither you nor Dr. Aniker tested the brain.
No, that is not true.
I'm sorry, imaged the brain.
Thank you. I did
Okay,
not.
So number 1, neither of you did number 1.
That is
And,
correct. sir.
and your testimony is you did number 2. You gave him 15 tests, right? And you're saying Dr. Aniker did not.
It was
right.
not evident in the report.
Okay. And you're testifying that the 3rd method is to look at the reported symptoms, correct?
Yes, sir.
And in fact, that's exactly what Dr. Aniker did. She included that. She just disagreed with your conclusion, right? She didn't deny he had symptoms.
I don't think that's true, sir.
That's right, doctor. In fact, she cites all the text message and many more than you do that when he talks about, I have hallucinations, right? She includes that in her report. Would you agree with me?
You did.
Okay, so what I'm trying to get at, doctor, is I asked you if it's a very thorough report. You said no. You said she didn't do testing. And I'm asking you, what else do you think was not in her report that makes it not complete or thorough?
Looking at cluster of symptoms, looking at the DSM, and based on the guidelines of the DSM, which is a diagnostic and statistical manual. If someone tells you as a psychologist, I am hearing voices. If someone tells you as a psychologist, I am seeing things. And if you look at their text messages, and in their text messages, it's replete with, I am seeing things. There's a demon in my house. Let me take a video. That is evidence of mental illness, sir. Mental illness is real.
So doctor, you have not answered my question. I'm not asking you if you disagree with Dr. Aniker because I know you do. What I'm asking you is, she references all that is missing from her report. Could you just answer just that question?
I don't know what else is missing from our report.
Okay,
sir.
so just the testing.
I don't know what else is missing from her report, sir.
All right. And in fact, her report cites extensively from the record. Would you agree? She cites a lot of text messages. Would you agree?
Yes, sir.
and extensively from the journal. Would you agree?
Yes, sir.
She talks about his internet searches. Would you agree?
Yes, sir.
The bird video,
Yes, sir.
the video of the school shooting,
Yes, sir.
her own questions of the defendant, his responses regarding those things, correct?
Yes, sir.
All right, other than your disagreement on the diagnosis, is there anything in Dr. Aniker's report that you believe is factually incorrect?
Just to clarify, my response is not my disagreement with Dr. Aniker's report. I've never met Dr. Aniker. What I am saying is that I don't know what her conclusions are based on. I don't know. It's not on the DSM. It's not based on testing. I don't know what the conclusions are based on.
Doctor, I've asked you a straightforward question is, are any of anything in her report factually incorrect? It's a yes or no question, whether you believe she had something that's factually incorrect.
It's difficult for me to answer that question, sir.
Well, you didn't highlight or note that she got something wrong, did you, in terms of the facts?
And the reason why it's difficult for me to answer that question.
Doctor, you can address that and redirect. I'm not concerned with why it's difficult.
Thank you.
Okay.
Just one moment.
Yes.
Doctor, I'd like to show you Dr. Aniker's report. You indicated you did review it, correct?
I did, sir.
May I approach the witness, Your Honor?
Yes, and could you just reference which exhibit that would be in your binder?
Your Honor, this is not yet an exhibit, but I am going to move to admit it. Doctor, may I approach, Your Honor?
Yes.
Doctor, I'm showing you what's been marked as People's Exhibit 64.
You recognize that?
I do, sir.
Is that the report you reviewed?
Yes, sir.
Your Honor, at this time, move to admit People's proposed 64.
Any objection?
No objection.
Thank you. Plaintiff, excuse me, people 64 is admitted.
Provide the corporate copy.
Yes, please.
Doctor, I want to look at page 61 of Dr. Aniker's report. I want to read you some statements from Dr. Aniker's report and ask you if you agree with them. Pretty close to the end, Doctor. It's 67 pages, I think, and it's page 61.
Thank you. I'm there now.
All right, so I'm looking at the first full paragraph on the page, and I'm going to go through a few of the statements there. If you look at the first sentence, Dr. Aniker indicates, when considering the question whether the defendant was experiencing a substantial disorder of thought at the legally relevant time, there is no indication from objective sources that the defendant engaged in unusual behavior that would be typical of psychosis in and around the time of the alleged offenses. Do you see that?
I see that, sir.
Do you agree with that?
I don't know what those objective sources are that she's referencing.
Well, that's what my question to you, doctor. She said there aren't any. And what I want to know is, do you have any objective sources that the defendant was experiencing or was showing unusual behavior that would be typical of psychosis in and around the time of the alleged offenses? Do you have any objective sources you would point to?
I do.
Please tell us, doctor.
We all saw the video, sir.
The video of the shooting.
We saw the video of the shooting.
All right. And you're saying he's exhibiting signs of psychosis during the video of the shooting.
We saw the video that he made the night before. We listened to him saying, "I am a demon."
I'm glad you brought that up, doctor. Do you know what that's in reference to?
I don't know.
Do you know who the defendant's idol is?
I don't know.
You didn't ask him that?
No, I don't know.
He references it in the journal. Did you not read the journal?
I read his journal.
Okay. And you know he idolizes another school shooter. Are you aware of that?
I am aware of that.
Okay. And
For someone to verbalize that tells me that person has a serious thought disorder.
so if I say to you, doctor, you know, that other school shooter referenced demons and I really think he's great, you're going to say I have some evidence of psychosis because I referenced that and I admire that person.
I would say you have some serious issues. Okay.
Any other objective evidence?
I'm sorry, sir.
Any other objective sources that you would rely on other than the two videos you just referenced?
Objective evidence will be testing, which wasn't done.
No, doctor, objective sources means independent, not self-reporting. A lot of your testing is self-reporting. I'm talking about objective sources. Let's help with this, doctor. Can you explain to the court the difference between objective sources and
and that infuse my opinions. That's my definition.
But doctor, it's not just your opinion, it's also the defendant's opinion. You're looking for something that is not based on his opinion or yours that's objective. So you'd agree like the videos are objective. The video's the video, right?
Yes.
Have any other objective sources that Mr. Crumbley engaged in an unusual behavior that would be typical of psychosis in around the time of the alleged offense?
I do not.
Okay. All right, moving down that paragraph, doctor, it says, this is Dr. Anaker's analysis, there is ample audio and video recordings of Mr. Crumbley both immediately before and immediately after the shooting. In none of the videos that this writer reviewed does he appear to be in the midst of a psychotic episode. In the videos immediately after the shooting, the defendant is observed communicating clearly with the police in a way that appears rational and relevant, suggesting reality-oriented thought processing. Are you aware of the video that she's referring to?
I am not, sir.
Okay, did you review videos of him shortly after the shooting?
I did not see the videos of him outside of the school.
So you did not see the videos of him in the sheriff's department vehicle?
I did not, sir.
And you did not see the videos of him sitting at the sheriff's department substation?
I did not.
Would you agree that those are objective sources that would allow you to get a look into what the defendant was, how he was behaving, and whether he was engaged in unusual behavior around the time of the shooting?
I do agree, sir.
And did not see those, correct?
I did not see those videos.
She goes on to note, in that time frame, the defendant does not mention parent questions asked of him in a coherent manner. He does not appear to sound or behave in a organized
I actually agree with that opinion, sir.
Okay. He follows commands, answers all questions. In a coherent manner. You agree?
I do agree, sir.
All right. Also, there's documentation from the jail, which I think largely consists of Dr. Kadir's reports, also the reports that deputies do when they go by on watch and they make notations about the defendant. Did you see those reports?
I did, sir.
And the defendant was constantly monitored, correct?
Yes, sir.
Either continuously or every 15 minutes, right?
Yes, sir.
And so those observations are recorded by the officers that are watching him, right?
Yes, sir.
And would you agree with Dr. Anaker that there's no evidence that Mr. Crumbley exhibited thought process? I'm sorry, that the videos tend to show that he exhibited thought processes that were grossly organized, goal-directed, and linear, with behavior that was appropriate. Jail staff did not observe him to be responding to internal stimuli. Would you agree with that?
No, sir.
Okay, tell me why you disagree.
The entire courtroom watched 5 videos of Ethan Crumbley in psychosis.
Okay, and I understand that's your testimony, doctor. That comes much later. Right now, I'm talking about around the time of the shooting.
Okay.
And what I'm asking you is, when Dr. Anaker is talking around the time of the shooting, would you agree that the defendant exhibited thought processes that were grossly organized, goal-directed, and linear, with behavior that was appropriate? Jail staff did not observe him to be responding to internal.
And the question, I don't know why he was in the school, at the sheriff's office, or the Oakland County Jail. I want to answer you, but I want to understand what it is that you're asking of me, sir.
Let's start from where the shooting video starts until he leaves Children's Village.
Yes, sir.
Right? During that time, would you agree that he's exhibiting thought processes that were grossly organized, goal-directed, and linear, with behavior that was appropriate, and jail staff did not observe him to be responding to internal stimuli? Do you agree with that?
Okay.
Do you agree with that?
Yes, sir.
Can you briefly explain, doctor, what does responding to internal stimuli mean?
So an internal stimuli is responding to auditory hallucination. And what that means is that it happens in an episodic manner. So I could be experiencing internal stimuli right now, and then I can step away and I am not experiencing internal stimuli. It is a very absolutely.
They might one day be doing it, or one moment, and then later they're not, correct?
Yes, sir.
And what I'm asking you is, what does that look like when they are responding to internal stimuli? What does that mean?
So it varies from person to person. Some people may smile inappropriately, and some people may try to mask what they're hearing by pretending that they're not hearing. And then you have some folk who may actually respond to internal stimuli.
Okay.
So people react differently based on the source of that stimuli.
All right, and you would agree what that boils down to for the layperson is someone is seeing or hearing things that aren't there, right? It's something that is internal to them and not in the world that all of us are observing.
Yeah, it's their perception.
So, doctor, I think you testified that you believe the defendant has a mental illness that constitutes a substantial disorder, correct?
I did.
And that you believe it significantly impaired his judgment, behavior, and capacity to recognize reality?
I did.
Okay. And doctor, is it your testimony that this defendant is not criminally responsible?
My testimony is that Ethan Crumbley is mentally ill.
I understand that. And now I'm asking the next question, which is it your testimony that he's not criminally responsible?
Your Honor, I'm going to object. That is not what we are here to argue today. We are not arguing criminal responsibility. The defendant has pled and we withdrew our insanity defense notice.
May I respond, Your Honor? I
Yes.
think it's very important whether this doctor thinks that he is not criminally responsible. If that's his opinion, I think the court can take that into consideration.
If your objections overruled, I'll allow some leeway. You may continue.
So Ethan Crumbley has pled guilty to the crimes. The facts are the facts.
and they cannot be taken back, sir.
Doctor, that's not my question to you. My question is, you understand the legal concept of criminal responsibility, and you yourself have prepared reports regarding criminal responsibility in other cases, correct?
That's correct.
So you understand the legal standard.
Yes, sir.
You know, the first step is mental illness that's a substantial disorder that significantly impairs the defendant's judgment, behavior, capacity to recognize reality, right?
Yes, sir.
And you've already identified, in your opinion, he meets that criteria, right?
Yes, sir.
Now I'm asking you the second step. Do you believe that he's criminally insane?
I believe he's mentally ill, and his mental illness played a factor into the events of the shooting.
So doctor, it's a yes or no question. Do you believe he's criminally insane or do you not believe that?
He's already pled guilty, sir.
Please answer the question directly, doctor, if you can. Please re-ask your question.
Is it your opinion that this defendant meets the legal definition of criminal insanity? Is that your opinion?
I don't think so, sir.
Okay. And why is that?
Can you rephrase that question, please?
Why is it that you believe he suffers from a statutorily defined mental illness, but you do not believe that he's criminally insane?
So I believe he has a diagnosable mental illness, and he engaged in a horrific act which took the lives of several students, and he's pled guilty. And my understanding is that he was found to not be criminally insane, and I will go with that opinion, sir.
Okay. And you know from your own work what the second step is after mental illness, right? What is the second step? What is it that this defendant does not have that makes him not criminally that makes him not insane?
That's a very high standard one has to prove. One has to prove that a mental illness was directly related to the act that followed.
Right. And so, doctor, the legal term of his conduct. That's the standard, correct?
Correct.
And in fact, to the lay person, it means the defendant knew right from wrong, right?
That is correct.
All right. So, doctor, one of the things you rely on to substantiate the mental illness and this psychosis you talk about are the text messages that you include in your report, correct?
Yes, sir.
And you say that the statement that he's without question someone who's mentally ill is substantiated by those text messages. And I want you to turn to the pages of your report that include those. That's pages 8 through I think 21.
Can you just reference which report, the June or January?
The June report. Thank you, Your Honor. And I'm going to try to stick to the June report now.
Thank you.
So the text message that started on page 7 of your report. Okay. And there are 14 pages, and I think you've agreed with me, ballpark about 200 text messages, correct?
Yes, sir.
How many text messages did you actually review?
I don't have an exact number, and so I can't give you an answer to that. What I do know, I reviewed, and again, I don't want to give an incorrect answer. I'm thinking I saw 20,000 text messages.
Okay, so how did you decide out of all the text messages, which ones to include in your report?
I decided based on the fact of just logic and process of elimination, because it's not appropriate. I didn't feel for me to include 20,000 text messages in a report. It wouldn't serve anyone any good. So I looked for themes. What are the themes in the text messages? And I included those that I felt were in that theme of mental illness.
So doctor, that's actually very remarkable to me. You reviewed 200, you pulled 200 text messages out of roughly 20,000, right?
That is correct, sir.
Okay. And you said you chose themes that sort of brought out what you were trying to illustrate and that supported your opinion that the defendant suffers from mental illness, correct?
Okay.
And doctor, all of the texts you cite are from one date, April 5th of 2021. You want to take a look at your report?
Certainly. That is correct, sir.
So you cite about 1% of all the text messages and all from the same date, and you indicate that 1% one day substantiates mental illness, correct? That's the basis of your opinion.
So the basis of, no, that is not correct, sir.
Okay. How come you didn't cite any other text messages, doctor?
A number of the text messages were not germane to the report. They were just innocuous. I can give you examples if you want, sir.
Let's turn this around, doctor. You agree with me, you cited only from one day, correct, in your report? Okay. And what you're telling me is the only germane text you found were from one day.
That is correct.
And it's like, I gotta do the math. 7 months before the shooting, correct?
That is correct.
And so everything you saw, you say that one day, that's the one I'm gonna hang my hat on. That's the one that tells me that he suffered from a mental illness when he committed the shooting, right?
That is not correct.
Okay. Explain that to me.
My opinion and my conclusions are based on my testing.
All right. Thank you, doctor. So, doctor, someplace in your report, I think it's after the text messages, you reference the time of those texts. You recall that? Find the page. It's page 22, and it's the third bullet point at the top.
That is correct.
And you say most messages were sent at 4 a.m. T and C, it stands for Coordinated Universal Time. I know the letters are out of order, but it stands for Coordinated Universal Time. Are you familiar with that?
I don't know if I am, sir.
All right, so doctor, you based your assumption that these messages were sent around 4 a.m. based on the little time indicators for each message, right? They each say 4, 5, 20, 21. They start at 3:50 a.m. and they go until (4:41 a.m.). You see that?
Okay, I agree, sir.
And doctor, in fact, every one of them says afterwards UTC plus 0, right?
Okay,
And you agree with that we're on Eastern time, right?
that is true.
And are you aware that Eastern time is UTC minus 4?
Okay,
Are you aware of that?
okay, sir. Yes.
So those messages were in fact sent between 11:50 a.m. and 12:41. I'm sorry, 11:50 p.m. and 12:41 a.m. Are you aware of that?
I am not, but I agree.
So your assumption that they were sent around 4 a.m. that's an assumption you made, and it's just not true.
Okay,
Doctor, you testified that you have seen the defendant recently, or at least during your testing, and that you agree he is competent to stand trial.
I did.
Okay. Doctor, you were played the jail camera video, right? That you discussed where the defendant is showing signs of attention, right? You're the ones who said this is concerning behavior, right?
That is correct.
All right, and you then reviewed that, didn't you?
That is correct.
And you consulted counsel and you were asked your opinion, right?
That is correct.
About whether this person was psychotic or competent and able to proceed with this hearing, right?
That is
And
correct.
you said he is, right?
Yes, sir.
You also would agree with me that behavior comes after the defendant had been in the jail in a one-person cell for 16 months?
That is correct.
And you would agree with me that the defendant was not behaving that way right before, during, or after the shooting? You'd agree with me? Okay. Would you agree with that?
I don't have evidence otherwise, so yes,
Okay. He wasn't behaving that way when you interviewed him, right?
he was not.
He hasn't been behaving that way during this hearing, right?
That is correct.
And so this is the only incident you're aware of where the defendant exhibited that kind of behavior.
Can you rephrase that question, please, sir?
This is the only incident you're aware of where the defendant has exhibited that kind of behavior. Another instance where the defendant was behaving like that Did you observe the defendant during the testimony in this hearing?
I did not, sir.
You did not.
No, sir.
When the video of the shooting was shown?
I did
not. When the two students were testimony or sees that video?
I think it's important.
Doctor, I want to talk to you a little bit about remorse. I think you say that the defendant is sorrowful that he's experienced.
He made.
Do you know roughly when that was?
On page 26.
All right, so page 26 into page 27. Here. You mentioned several times, quote, the stressful event. Do you see that?
Yes, sir.
And then you conclude that the defendant probably has PTSD, correct?
Yes, sir.
What is the stressful experience you're referring to in your report? All right, Doctor, I'm sorry, we're looking at page 26 into page 27 of your report, and you refer to the stressful experience. You refer to it four times. You see that?
Yes.
What is the stressful experience you're referring to in your report?
So those are actually questions on the PTSD questionnaire that he endorsed.
Okay. And what I'm asking you is, you referred to it multiple times, and I'm asking you, what is the stressful experience?
Of dealing with the consequences of his actions, of dealing with depression, dealing with nightmares, dealing with his current circumstance.
So that's a result of the shooting he committed, not a cause of the shooting he committed. Would you agree with me?
Yes, sir.
All right. So his PTSD, his post-traumatic stress is from the shooting that he committed.
Yes, sir.
Judge, I have quite a few more questions, and I did not realize time is.
Sure, we'll take a natural break. Please continue.
All right, Doctor, you indicated at the bottom of page 27 that the defendant, quote, feels guilty all the time. You see that?
I'm getting there, sir.
Page 27.
What part of the page you're looking at?
It is almost the last, it's the second to last sentence on the page.
Yes,
Notable responses to this inventory were the following: I feel guilty all the time, right?
that is correct.
And you don't indicate what he feels guilty for, right?
This is in reference to the Beck Depression questionnaire. There's a series of questions on there.
Okay.
So the prompt was, do you feel guilty at all sometimes? And so he endorsed that.
All right.
He feels guilty all of the time.
All right. So that's just a questionnaire and it doesn't say, what do you feel guilty about? It says, do you feel guilty all the time?
Correct.
Okay. Judge, I do have another series of questions. I think this is for me a natural break if the court is all right with that.
Sure. We can go ahead and take a break. We'll go ahead and break for lunch, but I'm not going to take an extended break as we're going to finish this hearing today. And so with that being said, we'll return at 1 o'clock and we will continue with the cross-examination at that time.
Thank you, Your Honor.
Thank you. Deputies may take the defendant. Please be seated in the courtroom until the defendant has exited. Thank you. I'll see you all at 1 p.m. The court stands in recess, or you may step down.
All rise.
barred at the hearing. He will also allow pictures of the victims' bodies to be shown, as well as video of Crumbley torturing a bird. Crumbley, who pled guilty to killing 4 and injuring 7 others at Oxford High School in 2021, was also denied other requests earlier this week. Crumbley's Miller hearing is set for July 27th, where it will be determined if he gets a life sentence without the possibility of parole. Well, joining us now to talk in studio about this case in depth here is Vonda Evans, who spent more than 2 decades on the benches as a judge in Wayne County. Thank you so much for being with us
And
tonight.
thank you for asking me.
So when you look at this case, it's obviously complicated because you're talking about somebody that was 15 years old at the time. When you look at what has been denied this week so far, does that lead you in any direction on how this judge will decide the sentence?
Not really. Under Miller, you cannot, Miller versus Alabama, you can't just give a juvenile natural life without first having a hearing. And basically, the hearing has to say, this person is not redeemable. They cannot be rehabilitated. They're done. There's several factors that you look at: the nature of the offenses, whether peer pressure, family, etc., and the brutality of it. But you have to balance that. What the people who represent him going to say, hey, you know what? What did you do at 15? Did you do something that's so bad that you were not now redeemable, that you can be rehabilitated? This is hard. It's a challenge. You're asking the judge to look in the future in a crystal ball and make those predictions.
But why would a judge, in a sense, want to have family members and others go through this again by having those pictures of the victims' bodies be shown, to have video of that deadly day at Oxford High School? Why would the judge want that to be allowed to be shown in court?
Obviously, it's very, terrible, and it evokes a lot of emotion. But it goes to show planning. It goes to show that he was a lone participant. And it goes to try to say, can we look at factors to predict, hey, maybe this guy doesn't need to be out. Maybe, he needs to be in prison for natural life. You have to weigh and balance.
But my thing is, we already know that, right? So we already know.
No, he doesn't have to. The judge can then say, listen, you know what? I'm not going to give him natural life. I'm going to give him 25 to 40 on the low end. So she can give him 40 to 60, 40 to 80, but she can't give him 50 to 100. So that's the range if she decides or he decides not to give them natural life.
I'm going to put you on the spot here. If you were the judge in this case,
okay,
how would you rule here? Because it's an incredibly hard decision. Some people would say, look, he did what he did. He was 15 at the time, but he deserves life without parole. Others will say, perhaps he can be rehabilitated and deserves a second chance. And there's going to be extreme opinions on either side. If you were the judge in this case, how would you go?
Well, unfortunately, I wish I could be, it was something that easily I can say. One of the things that I do believe is going to come out is going to be a mental health issue. Okay. And the thing about it is that they're going to argue, listen, this young man needed mental help. He never got it. Let's try to give it to him and see what happens. This is a hard call. And that's why judges get paid the big bucks. They have access to more information than you or I have. We only know what they release, but it's a hard one. And I know that this judge is going to make the right decision. But there's even a cases out of Oakland County now that says even 18-year-old, you got to look at it before you give natural life. So guess what? It's a challenge, but I know the judges is up to it.
As a former judge, what is the judge essentially going to be weighing here in that moment, in that courtroom?
Are the actions by him at 15 so egregious that we just throw them away and we say natural life and that's it? And Miller started talking about the development of the brain. that young people don't value things, or they can't assess things the same way that an adult. It's like anything else. A 15-year-old versus a 20-year-old versus a 21. There's a line, but the immature brain has not completely developed. And that's what Miller was talking about. This is a hard call. There's going to be a lot of motions. There's going to be a lot of witnesses, psychologists, etc. And it's going to be it's a lot. And you know what? People don't realize what goes into being a good judge, but this is a good judge, and I know that they'll come out with the right verdict. But guess what? This is going to be played out in the appellate court for years to come.
We're obviously discussing the Ethan Crumbley case as it goes to a Miller hearing next week. We're here with a former judge. And have you ever presided over a case that has been perhaps so difficult?
Anytime there's a loss of life, whether it's in the media or not, it's bad. There are no winners. You have the family of the deceased. You have the family of the defendant. There are no winners here, but you got to make a judgment call.
And there's justice, though.
Listen,
as hard as that is.
Exactly. And you have to make the right decision. What makes this even more challenging is the youthful age of this young man at the time that he committed it. So there are a lot of more factors than it would be if he were 17 or 8 or 19 or 20. It would be easy.
And when you see this situation here,
he has no prior criminal record. So that goes in his favor. So they're balancing. And you're asking the judge, let me look into the future and say, listen, this guy's not redeemable. But what we do is there's a presumption that over 19, 20, guess what? You commit a crime, you get natural life.
What are we looking at here? I mean, you're talking about potentially on the low end, what it might be. Where does this range fall in? I mean, it's either obviously
25 to 40, low end. So the judge can say 40 to 80. Which means that he would have to complete 40 years before he would be eligible for parole, which does not mean that he would be released.
Right.
Life without parole is a very extraordinary long, and it's a bad sentence. And there's a lot that goes into it. And that judge has to look at a lot of stuff. And the main thing is the development of the brain at the time of the commission of the crime, because juveniles access or process information a lot different than adults do.
Sure. And what have you seen over the years when you're talking about the development of a brain, when you're talking about somebody that is a teenager, that is young, that they have gone through a difficult thing? What have you seen in trials like this?
You know what? Ask yourself, what difference did you make at 15 till now? It's very simple. At 15, you're very impressionable. That's why peer pressure is one of the things that they look at, because young minds are very susceptible to peer pressure. They may not have received any mental health treatment. The killing of the bird, goes both ways. Hey, he was crying out. He needed help and nobody listened. His family wasn't there. Let's try to rehabilitate him by giving him some type of meaningful counseling, and that hopefully one day he can be out. That is going to be the goal of the defense. And this is going to play out probably to the United States Supreme Court.
What is the difference in a situation like this where a teen is charged as a juvenile or charged as an adult?
What's the difference? Okay, well, when you have a child or a young person, they can hold them to 21, and then they can do other hearings to determine. They can do up to 21 in juvenile sentence system. They can give them what's called a blended sentence, a little in juvenile and a little in adult, and or they can give them a sentence as an adult. This is a sentence as an adult, natural life, or any terms of years from 25 to 40. You don't give juveniles that. So if a juvenile had committed this crime and they were being sentenced in juvenile court, they cannot receive 25 to 40 unless there's a blended sentence. And that means that case is actually going to be decided in the circuit court, not just the juvenile court.
As a former judge, would you have liked to see anything different in a case like this?
Well, you know what? Time and time again, I hope that this case showcases we need to start early, give our young people mental health treatment. They're crying out for it. And parents need to realize there's nothing wrong when you see your child acting a little, confused. Give them some help. This is the elephant in the room we got to identify. Maybe if someone had given this child mental health help when he was suffering, going through this, maybe this might have not happened. We got to identify the elephant in the room, because if we don't, we're going to end up in situations that are horrific like this. And then we're going to try to look into a crystal ball to determine, is this person rehabilitated and what, and it's easier, in my opinion, to do it before it happens than after.
All right, former Judge Yvonne Evans, we appreciate it. We're going to continue this conversation when we come back after the break.
Thank you.
I don't know if there's been a better time to start a brand new news operation.
The newsroom was pretty much starting from scratch.
It's fresh, it's innovative.
Lots of energy, lots of passionate reporters.
Knowing what we're starting here puts so much joy in my heart.
We have reporters who are embedded in these communities.
We are part of the neighborhood. Our newsroom is part of your neighborhood.
People try to create feelings just the same as love, in the name of love, in the name of love. For the sake of daily passion, make a game of love, in the name of love, in the name of love. Jumping up and down on your emotion, just another way to break your heart. And it really makes you wonder what became of love, in the name of love. They make all the sacrifices for the sake of love. What they make of love is old heartbreak of love. When there ain't no giving in the give and take of love, put blame on love, in the name of love. Jumping up and down on your emotion, just another way to break your heart. Oh, there really ain't no feeling quite the same as love, in the name of love. People try to create feelings just the same as love, and they do it in the name of love. In the name of love. For the sake of foolish passion, make a game of love, and they do it in the name of love. Do it in the name of love. Coming up and down with real devotion. No, there's a better way to win my heart. And it really ain't no feeling quite the same as love. I know when you feel it, can't let go. I know when you got the habit, you just can't say no. I know when you feel it. I believe when you got the habit, you can't say no. I know when you feel it, you just can't let People try to create feelings just the same as love. In the name of love. In the name of love. For the sake of daily passion, make a game of love. In the name of love. In the name of love. Jumping up and down on your emotion. Just another way to break your heart. And it really makes you wonder what became of love. In the name of love. They make all the sacrifices for the sake of love. What they make of love. There's a whole heartbreak of love. When there ain't no giving in the give and take of love. Put blame on love. In the name of love. Jumping up and down on your emotion. There's another way to break your heart. Oh, there really ain't no feeling quite the same.
Jana Humphreys. Tonight, we're going to take you to day 2 of the Miller hearing of the Oxford High School shooter. This hearing will decide the fate and whether or not a life without parole sentence is appropriate. Our Gino Vici was in the courtroom all day long. We're going to send you to him now.
Just when you thought this hearing couldn't get any more emotional, the assistant principal, as you heard, testified. Christy Gibson Marshall testified that she knelt down beside the body of Tate Meir, laying on the ground lifeless as she tried to revive him. The family broke down. Gibson Marshall also broke down, and she said she came face to face with the Oxford shooter moments later in the hallway and asked him what is going on. He ignored her and walked right by with a gun in his hand. And across the courtroom, the defendant showed emotion for the first time since being inside of a courtroom. He began to cry. Keenan Gregory also took the stand. He was inside the bathroom where the Oxford shooter shot and killed Justin Schilling. Keegan thankfully was able to escape. He now has a tattoo with 4 halos on his arm with Roman numerals of the date of the mass shooting One of the halos is red, symbolizing that Justin Schilling saved his life. And more tears and cries from family members inside that courtroom as he described his encounter with the Oxford shooter.
When he moved the gun away from me, his side kind of, I ran behind his back and out the door.
Okay. Why did you do that?
Because I think when I saw his body, I realized that if I stayed, I was going to die.
The prosecution rested their case just before lunch today. The defense spent the afternoon interviewing their experts, but Judge Rowe says this hearing should wrap up on Tuesday, but it's possible a decision will not be made for days, potentially even weeks. Reporting outside the courthouse, Oakland County, Gino Vici, CBS News, Detroit.
Thank you, Gino. Joining me now is former Wayne County Circuit Court Judge Vonda Evans and an attorney who is a leading expert on these Miller hearings here in Michigan, Sanford Shulman, as well as former Wayne County Prosecutor Todd Flood. Thank you all for being here today.
I feel like I'm back at Third Circuit. Todd was my prosecutor at one time, and Sanford had me get reversed most of the time. So I feel like, all I need is my gavel.
Well, I'm so appreciative that you are all joining us today. This is a lot to take in. This is a lot to witness as this Miller hearing continues. Sanford, I'd like to start with you since this is your forte. For our viewers who are just joining us, can we talk about the point of a Miller hearing and what will be determined?
Well, Miller hearings didn't exist until the U.S. Supreme Court said that juveniles cannot be sentenced to mandatory life automatically. Before that, a sentence of mandatory life was really just cut and dry. And it was, if someone was convicted or pled guilty to first-degree murder, it was mandatory life. But the Supreme Court said that juveniles aren't mature, their brains haven't developed, and so they said before a judge considers a mandatory life, they also have to consider something less than that. 25 to 40 years is what the Michigan legislature said. So that's what the Miller hearing is. But in this case, what makes this particularly interesting is that the defendant is only been in custody for about a year. Most Miller defendants have been in custody for decades. So the defense has a huge file of prison records to show what he's been doing, what he or she has been doing, remorse and rehabilitation and programs. He doesn't have that in this case. So that's why it's challenging. But the real untold story is the judge, because the judge has to decide whether to impose a mandatory life sentence or something between 25 and 40. And that's the real story, because this is wrought with emotion. This is probably as emotional as you get. Your segments, even watching parts of it, is wrenching. But the judge watches the whole thing, and he has to be unbiased. He has to be detached. And yet he still has to make that determination. That really is part of the story, and I think that's the untold part.
And there are these factors you mentioned that have to be proven, and the burden of proof is on the prosecution. Todd, what is their goal? What picture are they trying to paint here?
This man doesn't have a conscience. He's for all practical purposes, someone that would be a serial killer otherwise, right? So when you think about this, his home life, yes, he comes from a sad tale of woe. All right, I give the DNA's there, but that's not the rest of the picture. Think about more. They got to be able to show the big question. I think the judge hit on this earlier, rehabilitation. Can he be rehabilitated? And candidly, when you look at all the factors in this case, when you look at, as the judge takes in his discretion, whether or not he goes with the life without parole, the premeditation, the fact that he kills for pleasure, he wants to seek pleasure in pain, those demonic thoughts of finding some pleasure in killing another human, to me, you got both the environment, you have the DNA. I understand that there may be questions about, redeeming him, but I don't see it. I don't see a shrink. They put a shrink up on the stand today, the defense. I listened to that, and it was about general topics. It wasn't specific as it related to this shooter. It wasn't specific I examined him and I found that this was missing.
You think that was by design?
No, I think that the fact of the matter is they didn't have it. They didn't have the facts and the absolute evidence to show that he could be rehabilitated. That's a key. And Sanford's point is you don't have a history with him. You don't have a history in prison with him. But candidly, what is his cause to kill? You may kill somebody because he's coming after your husband and you do it in self-defense. That's good cause, right? What does he do? He kills to get pleasure. To me, I don't see the redeeming quality in that.
Sure. The shooter's mental state is, of course, a factor. And we heard at least one psychologist or psychiatrist today say that he suffers from depression, the shooter. Barring any other mental illness, there was also a certain wherewithal there. There were time and time again, we have heard, he said he knew and understood that he would spend the rest of his life in prison. So Judge Evans, would that factor in at all if it were your decision to make? Is that something you can consider?
Well, I think that you have to look at what he's saying in the eyes of a juvenile. You can say anything, and then that reality comes, and what do we see? Him start to cry. Okay. I think that he looked at it and made a determination, but the reality, okay, I've seen grown men fall out when they get sentenced who thought that they could accept it. It's hard. This is a young man who's, according to doctors, there's not been sufficient brain development in the part of the brain to appreciate the wrongfulness of their behavior, to weigh the pros and cons as an adult would. Weighing pros and cons is different from a child than it is from an adult point of view. Okay, I think that we can all agree on that. And so this Miller hearing factors in the cognitive limitations of someone who is his age. And it's not just for him, it's generically, it's brain development.
Sanford, whether we are talking about a juvenile or even an older person, isn't it so difficult to prove, to predict in any case how someone's going to be decades down the line?
Yes, and that's why the defense has that uphill battle. I mean, Todd makes an easy case for the emotion on the victim's side with the family there, and they have witnesses, and the defense has what? I mean, they have some experts who don't have much of a record. So that's the challenge. But in the Miller hearings that I've handled, that was the same person that Todd saw in that chair today, but 30 years later, 40 years later. They were mentors, they were teachers, they went to church, they did astounding things in prison. And now they get a chance to get redemption, and they go before a judge, and the judge can feel the emotion and grants the motion, and the person walks out. The point is, this judge is making a decision not just on this defendant today, but potentially forever. I mean, 20, 30, 40, 50 years henceforth, a mandatory life sentence. And that's the challenge that the judge has to say. You judge him today, I can see it. But how do you do perspective in terms of rehabilitation and redemption? That's the challenge in this case. How do you find that?
And the challenge is that he doesn't get another chance. Okay. The other appeals that he have, they don't look at this. That's done. It's one and done. Whereas people who have been in prison for 20, 30 years, they have a plethora of information that they've rehabilitated. And so it's really presumptuous at best to be able to say he cannot be rehabilitated.
No, I take issue with it. If you just go with the whole year of him being in jail, you know what he looked up? He looked up how to be famous with this killing. He revels in the fact with this killing. He looked up in somehow, some way, this younger generation, he got a backdoor way to get onto the internet with his iPad. And he starts Googling life sentence. Can I get life sentence? And then reveling about the darkest spots of this. So I get it. I'm always want to give a chance. I give Karen McDonald credit for this. 19 cases she's reversed life sentences for with Miller hearings automatically from the previous regime. She takes this case and, we can all tell, Democrats, Republicans, she takes this case serious and she wouldn't be asking for life without parole, I think, unless she crossed all her T's and dotted all her I's. That's just my thought.
We do have to take a quick break, but the conversation continues right after. Stay with us. Welcome back. We continue our coverage of the Miller hearing that will decide the fate of the Oxford High School shooter. Today was day 2. The judge will eventually decide whether this teenager is eligible for a sentence of life in prison without the possibility of parole. It was another extremely emotional day in the courtroom. You're about to hear some of the testimony from some of the students who took the stand today, and because they are minors, we will only hear their voices. We do want to warn you that some of what you're about to hear is very disturbing.
What did that hallway look like?
It was chaos. There was someone trying to be resuscitated, and whoever was helping her was just yelling at her like, come on, you get this and stuff, trying to just get her to respond.
Do you remember where that blood was in relation to his body?
Around his head.
Okay. And the shooter tells you to do what?
Kind of signals me to go over by his body.
And what did you do?
When he moved the gun away from his side, kind of, I ran behind his back and out the door.
Okay. Why did you do that?
Because I think when I saw his body, I realized that if I stayed, I was going to die.
Just truly heart-wrenching testimony both days of this hearing so far. That last student, Keegan Gregory, was a freshman at the time when 4 fellow students were killed and 7 more people were wounded. Here with me today are Judge Vonda Evans and attorneys Todd Flood and Sanford Shulman. Let's talk about the nature of this testimony. It is so difficult to listen to. Judge Evans, I'll start with you. How much of a factor does that play in the judge's decision? Can it sway the choice here?
Well, it's very emotional. Being a judge is akin to being a doctor. You got to focus on what your job is. And that is to weigh those factors, to give respective weight to everything, and to make a decision. And you're a technician. That's what I would tell my jurors. You are you can't be moved by emotion. Yes, it's there, but you got to make a decision on whether or not the prosecution has met the elements, in that case, beyond a reasonable doubt. And this is what he's the trier of fact. So now his job is to determine whether or not the prosecution has met the elements beyond clear and convincing standard, which was what needs to be shown. So he's acting here as more of a technician than being human and letting emotions sway him. But it is a consideration.
He's listening to it in a different way than all of us at home might be. Todd, you've been a prosecutor before. What is the goal of the prosecution? It's not just to put on a gruesome show, of course. What is their goal in having the victim sort of relive this experience on the stand?
A good prosecutor would say due process. Let's just make it fair. I'm going to put the facts out. I'm going to do it right. Here is the law. Here are the facts. I'm going to present this to the court, and I'm going to let due process dictate. It's the judge, and Judge Vonda Evans, one of the great ones. She called it as she saw it. And the ground was heavy, and it was a difficult decisions that she had to make. Can't be swayed, but the fact of the matter is that a prosecutor in this particular case wants to present clear and convincing evidence. All of us wear white hats. There's no black hats in that courtroom. Defense attorneys and prosecutors, we all work in a fishbowl. Everyone sees what we do. So prosecutor's going to get up there and make sure that all of the evidence is presented to the court in a competent way to show all of the factors. That what you're seeing there in the testimony that took place was the circumstances surrounding the homicide, both pre, during, and after, right? He even talked about in his journal, when I do this, I'm not gonna shoot the police. I'm gonna put that gun down. I don't want to get killed. I'm gonna put that gun down. I'm gonna revel in this stuff. So it was clear those are circumstances that go to the mens rea, to the guilty mind, to show how he maturely thought about all the facts and circumstances around the case. That's one. The prosecution's going to show that. Prosecution really delved, I think, heavy into the facts and circumstances of this case, as opposed to some other things they could have done.
rephrase the question, sir?
Is growing up white in a mostly white school district a disability this defendant had to overcome?
I don't think so.
Okay. Did race make his circumstances more difficult?
I don't think so.
Was he discriminated against?
There's no evidence to show that.
So, doctor, would you agree with me that growing up white is not a mitigating factor in this case?
That is true.
Doctor, you testified that you reviewed the bird video and the manifesto video and the school surveillance video before you submitted your first report, correct?
I think so.
All right. And doctor, I'll tell you, and you can tell me if you disagree, but you don't mention those other than putting them in your sources in your first report. You don't mention them at all again in the rest of your first report. Would you agree with that?
That sounds about correct.
All right. In your June report on page 49, you spend about 2 pages describing what happened leading up to and on the day of the shooting, correct? If you want to look at page 49.
I take your word for it, sir.
All right. Your report's a total of 69 pages long, right?
That is correct.
And you spend 5 sentences on the journal. You disagree with that?
I take your word for it, sir.
2 sentences on the bird video.
I take your word for it.
4 sentences on what you refer to as the manifesto video, right?
I take your word for it.
And then you spend about a page that you label, quote, the day of the shooting. You want to look at that, or will you agree with me?
I take your word for it, sir.
But doctor, you really don't even spend a page describing the defendant's actions on the day of the shooting, do you? You never mention the defendant getting up early to get the gun and ammunition, do you?
It's not mentioned in my report.
You don't mention him packing it into his backpack?
It's not mentioned in my report.
Or getting himself to school?
It's not mentioned in my report.
Or getting into the school with the gun and the clips and the ammunition?
It's not mentioned in my report.
Or going into the bathroom?
It's not mentioned in my report.
Or putting toilet paper in his ears?
It's not mentioned in my report.
Did you ask him about that, doctor? Why he put toilet paper in his ears?
I did not.
And you don't mention the defendant shooting Phoebe, right?
I did not.
Or shooting Hannah, right?
I did not.
Or shooting, pardon me, Hannah or Madison. You don't mention that.
I did not.
Or Tate.
I did not.
Or
mention
Justin, right?
any- I did not.
Or Aiden or Molly Darnell or John or Riley or Elijah or Kylie. You don't mention any of that, do you?
I didn't think it was appropriate, sir.
Okay. That information was included, so you knew about it, you just didn't include it, right?
I did not mention any names in my report, sir.
Didn't mention any names. You don't talk about the defendant.
I do. It's on page 1, the first paragraph.
You know, doctor, it's interesting you bring that up because you didn't say allegedly the defendant did it. There is this defendant is responsible for the deaths of those kids. We'll get there. But you agree that was included in the materials you reviewed. You knew that information.
I do.
Doctor, you never talk about how many victims there were, do you?
I did not.
Isn't that relevant?
It is relevant.
Okay, but you don't talk about how many people he shot, how many people he killed, and how many he terrorized. You don't talk about that.
That is correct.
Doctor, you don't indicate how long the defendant spent walking through the school shooting people, do you?
I did not.
Do you know how long that was?
I do not, sir.
Do you think that matters?
Perhaps it does.
And you don't indicate the defendant's demeanor during the shooting, do you?
I did not.
And you saw the video, right?
I did.
Does not include audio though, does it?
I'm sorry?
That video does not include audio, does it?
Which video, sir?
Of the shooting.
I do not understand. The question does not include audio.
Correct. When you see the video of the shooting, there's no audio to that, right?
I don't think so.
Okay. Did you ask anyone what it sounded like inside the school during the shooting?
I did not.
Did you listen to the body cam audio and video of a staff member trying to save Hannah?
I did not listen to any audio, sir.
Okay. Does any of that matter to you?
It does matter.
Okay. In your report, you don't even include one sentence about how this defendant killed the victims to you.
It's not included in my report, sir.
All right. How far away was the defendant when he shot each of the victims who died?
Sir, I watched the videos and he was pretty close to them.
Pretty close. What do you mean by that? Point blank range?
Yeah, I don't know the exact measurement, so I can't testify to
It's
that.
essentially the gun to the head in most cases. You agree with that?
Those are the facts of the case.
Do you know where on the body he shot the various victims?
I do not.
In the head, the neck, the chest? You're not aware.
I believe one victim was shot in the head, at least one.
Doctor, are you aware of when and how the defendant shot Justin Schilling?
I am not aware, sir.
Okay. He's in a bathroom. He's in a bathroom. Do you know how long he was in the bathroom with Justin and Keegan before he shot Justin?
No, sir.
Do you know how he asked Justin to get down on the ground and then he executed him? Are you aware of that?
I take your word for it, sir.
Okay. Does that matter to you?
It does matter.
Doesn't it speak to the defendant and his state of mind at the time?
It does.
You think that's the product of a juvenile brain?
I do.
Okay. Did you ask the defendant about that?
I certainly asked him about the shootings.
Did you ask him about his motivation or what he was thinking when he did it?
I did, sir.
But you don't include that in your report, do you?
I did not.
Doctor, would you agree that being calm and methodical when you kill people is not a reflection of youth and impulsivity, is it?
Can you rephrase your question, sir?
No, but I can repeat it.
Okay.
Being calm and methodical when you kill people is not a reflection of youth and impulsivity, is it?
I think it's a reflection of what happened.
Okay, but it's not youth. Adults do that, right?
Absolutely.
All right, doctor, I want to move to page 67 of your report. When the defendant was sitting in the office with the backpack next to him, you say, the defendant started to feel a sense of relief, knowing that the sheriffs would descend on the school. You wrote that, right?
Yes, I did. Yes, sir.
And you characterized the defendant, we've talked about this, as someone who kept asking for help but never got it, right?
That is correct.
You cite times when he said to his friend B, I keep telling my parents I need help and they won't help me, right?
That is correct.
Doctor, that exact moment you're citing, when the defendant has the backpack next to him in the counselor's office, the defendant had the perfect opportunity to get help, didn't he?
Absolutely.
All right. And he didn't take that, right? He
That
didn't
is
take that
correct.
opportunity.
Those are the facts of the case.
Right. He'd asked for help many times, but when help is right there in front of him, he doesn't ask for help, does he?
That is correct.
And you'd agree if he just said, Mom and Dad, I need help, or I feel like there's no hope. I even brought a gun to school. They'd have given him help, wouldn't they?
I've never met his parents. I don't know how they would have reacted.
Well, the school, you don't have any reason to believe if he had said that he would not have gotten help, do you?
I don't know, sir. I don't know the answer to that question.
And it's not that no one believed him, right? He just didn't say it. You agree with me?
I do not agree with that, sir.
He never said it, did he? He never said it in the counselor's office. Did he tell you that he said, I really need help, Mr. Hopkins? I really need help, Mom and Dad? Did he tell you he said that?
He wrote on his paper.
Doctor,
I need help.
we've talked about that. He then tells them that the paper was part of a video game. He says, I'm not asking for help. That's what he says to them, right?
For the sake of brevity, sir, I will say yes.
Yeah, okay. So at that moment, doctor, the defendant, for whatever reason, decided he wasn't going to ask for help, right? But do you agree with me? At that moment, the counselor told his parents, you have to get him help within 48 hours, right? You agree with that?
I read that.
So at most, if the defendant's just not comfortable talking about it there, he's 48 hours away at most from the help that he's allegedly been begging for, right?
So he should have gotten the help right away.
Okay, doctor, but I'm talking about the defendant now, not the other folks in the room. The defendant now knows, after he's been asking for help for a long time. You cite April of 21, right?
Yes, sir.
He's less than 2 days away now, right? You agree with me?
I agree with you.
All right. And he doesn't choose to just say nothing and go home. He leaves that meeting and he goes to the bathroom and he takes the gun and he starts shooting, right?
Actually, no, sir. He went back to classes.
Okay. He went back to class, and instead of finishing out his classes for the day and going home and then getting help, he decided to start shooting.
No, sir. He went to the lunchroom and had his lunch.
And then he started shooting. He had time to think about it.
Yes, sir.
All right. Did you ask the defendant about that?
I did, but he did not respond.
Okay. On page 68.
You said, did you ask the defendant about that? Could you just clarify about that, what that means?
Yes. So, doctor, did you confront the defendant with the fact that help was now, he was on the precipice of help, less than 2 days away? Why did he start shooting instead? Did you ask him that?
I did not ask him that question.
Okay. So he didn't explain that to you.
That is correct.
On page 68, you describe the defendant, and I gotta look at the page. This is Doctor, on page 68 of your report, first paragraph, conclusion events, you say the defendant now returns to class with this feeling of terror and absolute astonishment. Those are your words, right?
Yes, sir.
And you're talking about the defendant. You're saying the defendant is the one who's feeling terror.
Yes, sir.
And then, doctor, even more remarkably, the sentence before that, you say, perhaps the saddest part of this very horrible saga is that the defendant was given his backpack with the gun and told to return to class. You've heard the testimony, doctor. You've read the reports. You've heard people crying in the courtroom. You've seen the families. And you're saying that the saddest part of this is that he was sent back to class. That's what's sad about this case.
Those lives could have been saved.
That's true, doctor. And who made that decision?
A number of people.
All right. Finally, doctor, on the very last page, you include one sentence that talks about the defendant murdering anyone. It just sort of hints at it. And in fact, in that sentence, you don't blame the defendant, do you?
What are you referring to, sir?
I'm talking about the one sentence where you ever talk about the defendant killing anyone. The only one in your entire report.
Could you just specify where this is?
Yeah, it's the last sentence under conclusion events.
Can you tell us the page?
68.
One moment, please. On page 68, the last sentence.
Of the conclusion events.
Oh,
Can you read that to the court?
says his obsessive thoughts and compulsion propelled him to take the lives of innocent people.
Doctor, is that really your opinion about how these murders happen?
Yes, sir.
When you talk about obsessive thoughts, obsessed with what? What is the defendant obsessed with?
With harming people.
That propels him to do it. He's obsessed with torturing birds and killing people, right?
That's correct.
Doctor, would you agree with me? You spend very little time discussing the journal in your report.
I spend time discussing it, sir. I
All
don't
right,
know
well,
very
let's-
little, but I
okay,
spend
all
time
right,
discussing it.
Okay, all right. So you don't discuss it at all. You've already agreed with me in your first report, your January report, right?
That is correct.
All right. And then in your June report, you spend 6 sentences on it, right?
I take your word for it, sir.
All right. And you pull out 2 quotes, right? One about my parents would listen to me and help me, or a therapist. I used to have a dream and I realized working hard for your whole won't do anything. That's the first quote you use in events leading up to the shooting from the journal, right?
I take your word for it, sir.
And then he includes a second quote where on page 49, I have this huge crush on a girl in my 6th hour. I want to ask her out, right?
That's correct.
Those are the only 2 quotes you use from the journal, right?
That's correct.
All right. And you spend almost no time talking about the birds or the bird video. Again, in your initial report, you listed it as a video and never mentioned birds anywhere again in your report. Would you agree?
He made a video of himself torturing birds,
Correct.
indicating his desire to make the birds feel
Hold on.
what he was feeling.
We're about to get there. That's 2 sentences in June, right? And in the first report, there's 0 sentences. You agree?
That is correct.
All right. And you say, as you just said, the defendant probably saw this as a way of releasing the pain he was feeling inside, right?
That is correct.
You don't explain that, right? That's it. You don't offer any further explanation of why you think he probably saw this as a way of releasing the pain he was feeling, right?
That is correct.
Did you ask the defendant about that?
I did not.
So, doctor, there are things you asked him and things you didn't. Was the defendant forthcoming with you?
Based on my testing, I believe he was.
All right. You do indicate in one of your tests he was over-reporting, right?
That is correct.
And doctor, you're aware of a discussion he had with a girl about being shot by his father with a BB gun? You're aware of that?
I saw that in one of the documentations.
Okay. And he acknowledged he lied about that, right? Sometimes he just makes stuff up.
That is true.
Did you ask him about why he killed baby birds and whether he liked it or not?
I attempted to.
Okay. And he didn't respond to that.
He's still trying to come to grips with what has happened.
Okay. And doctor, you really don't mention the manifesto video, right? You spend about 4 sentences on that and you don't quote anything from it, do you?
Sir, I believe I've answered that question. I did mention it in my report.
Doctor, hold on. I'm asking about a different video now. We're talking about the manifesto video, right? And you don't address that in your first report, but in your second report on page 50, you label video the night before the night of the shooting. It says video before night of shooting, but it's video the night before the shooting, right?
Okay.
And you include a couple sentences about that. It's actually not mostly about the video. You say, the night preceding the shooting, Ethan was locked out of his home by his parents following a verbal conflict surrounding his grades, right?
There's 6 sentences in that section.
Yes. And the first one is you talk about he'd been in a verbal dispute with his parents and his parents actually locked him out of the house, right?
That is correct.
In fact, he'd been locked out of the house when he made that video, right?
Yes, sir.
All right. You spend a couple sentences on it, but then you don't actually quote from it. You say the video shows him indicating his desire to harm students at the school, right? Those are your words, correct?
That is correct.
And you would agree with me, doctor, of the 20,000 text messages, you make no reference to 99% of those. You just include the 1%.
That were relevant, yes.
And doctor, in your report, at least, you never talk about the defendant's internet searches. Agree?
That is correct.
And you were aware they existed. You testified you did pull out one about the dog, so you knew they existed. You just didn't reference them in your report.
That is correct.
In fact, you don't mention the shooting at all or the shooting video in your report, do you? You saw it, but you don't mention it, do you?
It's on page 1 of my report. The shooting.
What are you talking about, doctor?
You said I have not mentioned the shooting when I'm saying
Yes.
on page. one of my reported very first paragraph.
Oh, where you say he allegedly shot and killed four of his classmates? Okay. You never talk about the defendant's motivation, do you? You never talk about the defendant's motivation, right?
I mentioned his mental illness, sir.
Doctor, my question is not his mental illness, it's his motivation. Why does he want to kill people? You didn't talk about that in your report, did you?
I did.
Where?
In my testing, sir, I spoke about his obsession and his compulsions.
Doctor, I'm talking about what motivated him. Why did he want to kill other people?
I don't even think Ethan knows fully why he wanted to.
Okay. I'm glad you said that, doctor, because we're going to look at some things and see if Ethan tells us,
Sure.
the shooter tells us why he was motivated to do that. All right. Doctor, I'm going to show you a series of clips from the journal, the text messages, internet searches, and so forth. I want to go through those with you. All right, okay. First one, doctor, page 22 of the journal. And the defendant says, then I will walk behind any girl pretty and shoot them in the back of the head. I will then shoot everyone I see aiming for the head. You see that?
I do.
Next slide, please. I will continue shooting people until police breach the building. I will then surrender to them and plead guilty to life in prison. You see that?
I do.
Next slide, please. I want the world to remember me. That's in the journal, right? You saw that.
That is correct.
You don't reference that in your report, though, do you?
That is correct.
Next slide, please. Killing myself is too much of a pussy move. People will just forget about me, and I will have never making an impact in this world. The only way is to shoot up the school. You see that?
I do.
And you were aware of that. You read that, right?
I do.
Next slide. I'm going to kill many, many people for no sole reason. I'm going to rain fucking fire down on this school. I will cause the biggest school shooting in Michigan history. I will kill everyone I fucking see. You see that?
I do.
That tells us something about his motivation, right?
It does.
And in fact, he's right about Michigan history, isn't he? Isn't he?
I want to answer, sir. So far, yes.
Next slide, please. I want to remember throughout all of history. Right?
I see that.
Okay. You saw that before. I'm not showing you for the first time, right? You've seen the journal.
That is correct.
Next slide, please. I would just hope their parents will fill with sadness. And is it distraught? When I shoot up the school, I hope that every parent of kids I gravely murder will be so sad that they kill themselves. You see that?
Those are the facts of the case.
Hold on, doctor. It's not just the facts of the case. This is the defendant's own words, right? Okay. When they saw the video, when they show the video in court, everyone can see their children and friends dying. And I want for the parents to see their kids burned to ash and bawl their eyes out. I'm going to spend the rest of my life in prison. You see that?
I do.
Next slide, please. Defendant's journal, page 18. The first victim has to be a pretty girl with a future. You see that?
I do.
And it shows a gun to the back of the head of a girl, right?
I do.
Next slide, please. I know that rarely any shootings have happened in Michigan, so that means I will cause the biggest school shooting ever in the state. I am not going to tell myself I will surrender to the police. I wish to hear the screams of the children as I shoot them. You see that?
I do.
Next slide. So, doctor, on this slide, he's talking about what kind of weapon he has. You're aware at one point he has access to a .22 pistol, right?
I do.
And he says, I want to do the shooting with a 9mm pistol because they are effective from killing, but all I got is a puny 22, right? You see that?
Yes, sir.
And then he draws a drawing of two different bullets. One's a 22 and one's a 9mm. And you're aware, Doctor, one is a lot more deadly than the other, right?
I take your word for it, sir.
You're not aware of that? He was right about that, right?
Yes, sir.
Next slide, please. It just amuses me how I can cause people to talk about what I did, and it just makes me happy. Now he's talking about taking the bird head to school. You're aware of that incident, right?
Yes, sir.
And he says, now people are talking about me. That makes me happy, right?
Yes, sir.
I killed 8 infant baby birds by slowly torturing them until death, right?
Yes, sir.
These are the defendant's words after torturing the baby birds and before killing his classmates, right?
Yes, sir.
I murdered an entire family of 5 newborn baby birds. I drowned them and burned them alive while they all screamed. I cut one in half and stuck the head of its brother in its stomach. You see that?
Yes, sir.
Again, these are the defendant's own thoughts and words ahead of the shooting, right? Next slide, please. If I kill myself, then people will not care about me and I will be forgotten within half a lifetime. That's why I'm going to cause the biggest school shooting of this decade and the only one in Michigan, right?
Yes, sir.
I also want to react on how the world reacts to my shooting. I'm probably going to live the rest of my life in prison. You see that?
Yes, sir.
Next slide. He says again, I'm about to spend the rest of my life in prison, right?
Yes, sir.
Shortly before the shooting, I'm going to prison for life, and many people have about 1 day left to live, right?
Yes, sir.
All right. Now I want to go through some text messages. The defendant talking about violence against people. He's talking about drowning children. He says, just looking them in their eyes as they look back at you while they know that their entire life is about to end so young, the best feeling. But stick your fingers into their eye sockets and push down so they scream in pain and drown their lungs with water. Just thinking about the torturing and the screaming and the way their legs flail in the air as they cry, it fills the void. You read that, Doctor.
Yes, sir.
And again, you read that before your reports, but you decided that wasn't relevant to your report, correct? Correct?
They're all relevant to my report, sir.
But you didn't include it.
That is correct.
All right. Next slide. Whenever I see a little kid about a year old or a little more, I want to pick them up and run off with them, then torture them before throwing them off a cliff. And then I will kill any innocent. I don't care who I kill. I will kill who I feel like killing. Age, gender, I don't care, right? I don't care about innocent. Killing the innocent is the same as killing the bad. It both satisfies. You're aware of those texts?
Yes, sir.
Next slide. I want to take the axe and chip a bird in half, presumably chop a bird in half, shoot it, torture it, dissect it. I want to chop it in half with an axe. Talking about fish, then I want to kill it while it is live so that it can feel the pain. Next slide, please. More about the birds. Also, there is a baby bird nest right next to my house with 5 baby birds in it. I can also reach them. Tomorrow I'm making my move. I will get video and pics. I can't wait till tomorrow. There is 5 and they're going to die anyways. I want to take something heavy and break its beak. I can't wait, dude. I'm so fucked up. I'm going to break its beak, then chop its head off. I'm going to take so many vids and pics. You've seen all these, right, Doctor?
Yes, sir.
I want to hear it scream. The first bird, though, I want to torture it. And it's so young, too, like it's just born and it's already going to be killed. It's like 2 days old. I'm going to snap the beak off and then chop its head off, then take out its heart, then chop it in pieces, and also take out the brain, then smash it to little bits. I'm so fucked up, I like it. Jeffrey Dahmer got the good idea. Only thing he did wrong was get caught. More about the birds. I want to kill another bird so badly, or baby bird. I can reach into the nest. They're not safe. During third hour, all I thought about was ways to torture the bird. I'm going to film this like a documentary. My dad is pulling out of the driveway. Now, I'm going to wait a couple minutes, though, just in case he comes back. Right? So he's talking about his joy in killing birds, but also then what he wants to do to the birds. But Doctor, he doesn't just talk about it. Then he goes and does it, right? And he videotapes it. And then he texts his friend about right? And he says, I just finished. The vid is too long, so I can't.
You have to ask a question.
I'm sorry. So you agree with me that after he made those statements about his plans, he then did go and do it, right?
Yes, sir.
And you would agree with me that he then wrote about that after he'd done it, right?
Yes, sir.
And he wrote to B, right?
Those are the facts of the case.
All right. And what he said to B is, I just finished. The vid is too long, so I can't send, but I can send pics right before I throw it out. Sends a picture. I'm sorry, one moment. All right, so we're reading the text on the screen. It's so fucking, I can't wait to show you the vid. It's so fucking disturbing. And as I don't even remember saying half the stuff, like I talked to the bird like a little child while torturing. I can't wait to show you. It was so fucking fun. Thing is, the vid halfway through, so you can't see the good stuff. I put a drill in its stomach and skull. I also shot the gun at it a couple times in the stomach and its head. I also chopped it in half with an axe. I also smashed its head in with a hammer at the end, and its eyes bulged out just like Glenn's. Do you know who Glenn is?
I do not.
You know, it's a reference to The Walking Dead.
I'm not a movie fan, so I apologize.
Did you ask the defendant about that?
No, sir.
Like the eyelids came apart so that I could see the bird's eye. There are still 3 birds left. I was originally going to try to stick a toothpick up its ass, but I couldn't find any. God, I can't wait to show you the vid. It's 8 minutes long. Like I couldn't stop laughing my ass off when I rewatched the vid. Again, you're familiar with all of that.
Yes, sir.
All right, and now next slide, please. This is what I meant the other. So this is a text from the defendant to B. This is what I meant the other day of how I need a recharge to kill again. Now tomorrow I really want a bird, but I want it to be alive when I chop its head off. Right? God, I want to kill. I hit a bird yesterday 2 times, but it flew away. And continuing with the birds, there have been no baby birds to torture in for a long time, and I'm getting that feeling where I need to kill again. I like killing the big birds, but I like killing the baby birds more, mostly because they're so young and they had a whole life ahead of them, but then I took it away. That's what I like. And also they're helpless and they scream when you hurt them. Doc, you see a theme there with the students he wants to kill and the birds?
I do.
That he takes joy in killing younger people, younger birds. He talks about killing children, right?
He does.
So he talks about killing and then he talks about better killing. Would you agree? What makes him feel better?
I do agree.
Doctor, we don't need to spend much time on these, but you understand that in addition to his internet searches about a dog, he also repeatedly searched about prison sentences in Michigan. What's the worst prison sentence you can get? What is a life sentence? What is a sentence for a 15-year-old legal age to be sent to prison, youth correctional facility? What prisons are there in Michigan? The Oxford High School layout. And then this one's important. What is the average response time for a shooting? You're aware of all of those.
Yes, sir.
And then, Doctor, there's a little bit more. You reviewed the manifesto video, right?
I did.
And in the manifesto video, you heard the defendant say in his own voice, when the bell rings to end 5th hour tomorrow, October 30th, November 30th, 2021, I'm going to walk to the dividend between the boys and the girls' bathroom, and I will have my black jacket on, and I will walk behind someone, and I will shoot a bullet in their skull. Yeah, that's my first victim. I'm going to open fire on everyone in the hallway. The hallways are too jam-packed. I will try to hit as many people as I can. I will reload, and I will find people hiding. You heard him say that. You listened to that video, right?
I did.
And then you heard him say, I understand that I'm going to prison for this. Michigan doesn't have a death penalty. I don't want to die. As funny as it may seem, I want to kill a lot of people. I do not want to die. I realize how valuable life is. This is the defendant, 12 hours before he starts killing people, right? And he's expressing what he intends to do and then what he does do, right?
Yes, sir.
All right. And then you hear him say, just the thought of, oh, there's so many people who think they're going to live the life, going to go to college, have a great career, get a family, grow old, die happily, and what they don't know that in less than a day, they're going to die and their lives are going to be changed forever, right?
Yes, sir.
And he's right about that, right?
He's correct.
I understand my consequences. I understand that people put me in prison for this, right?
Yes, sir.
And then that first video ends, and then he records a second one saying, fuck that previous video I took. That was bullshit what I said. I'm going to have so much fun tomorrow. I have a goal, and it's to kill everyone. Right?
Yes, sir.
Now, doctor, you may say this is like grandiose juvenile stuff, right?
No, sir. That is very serious stuff.
All right. So when we look at the defendant's messages, doctor, he tells us a lot about why he's doing what he's doing. And that's why I asked you about his motivation. You talked about the testing, but he tells us, right, that what he wanted was to be famous, right?
That is correct.
That was his really primary, his only motivation. He liked killing, but he really wanted to be famous, right?
That is correct.
So we agree it wasn't a fight or a robbery. No one was defending themselves, right?
That is correct.
And he didn't want anything from the victims. There's nothing they could have given where he said, like, if you give me this, I'll spare your life. He didn't want anything from him, right?
That is correct.
All right. And none of them had done anything to him, right? He hadn't been bullied. He didn't even know these specific people he killed, right?
That is correct.
And he wasn't seeking revenge. It's not like someone had done him wrong and he said, you know what, I'm going to get him back for that.
That is correct.
And you would agree that that can be kind of a juvenile thing, right? You feel that you've been dismissed or mistreated and you want to lash out at that person, right?
That does happen sometimes.
And you agree this shooting is not that, right?
I do agree.
So his goal and the reason for the victims, he just wants to maximize the number of people he killed so that he can commit the biggest mass shooting so that he can be remembered, right?
That is correct.
We also learn about what kind of victim he's looking for, and we just talked about this. He wants younger victims, and he actually talks about probably not killing teachers, right?
That is correct.
All right. Doctor, this thing about the defendant specifically choosing not to kill himself, have you ever seen that before?
I have. Ethan is the only mass shooter that I've interviewed, sir. So I can't. That's it. That's my only answer I can give you.
All right. Have you? Okay. So you don't have experience with other mass shooters. You can't speak to that.
That is correct.
So it's important, doctor, at least to me, when he expresses what he's going to do, for instance, shooting people in the head, and that's what he carries through and does, right?
That is correct.
You know, doctor, you have this comment about the bird video, and you say that the defendant probably saw this as a way of releasing the pain he was feeling inside. Just so we're clear, you saw the slides. That's not what he said, right?
That's not what he said.
That's your impression.
That is correct.
Doctor, when you watch the bird being tortured, do you get any sense that that's difficult for the defendant, that made him uncomfortable? Did he have any qualms about it?
He de-associated from what was happening.
Okay, so the person who was torturing the birds didn't have any qualms, you're saying, but that's him dissociating from what?
From reality.
So you're saying he did that during the torture, but not when he's texting his friend and talking about it, right? Not when he's rewatching the video.
That is correct.
Doctor, you reviewed Dr. Aniker's report, and when he's talking about the birds, he says, it just made a good feeling, and I don't know how to describe it. I made a little area in my parents' shed, and I would form different torture techniques on it, cutting it or breaking its limbs, or drowning it or burning it. 7 baby birds in total from 2 different nests. And I would take the BB gun and shoot them or hit them with a baseball bat. He indicated he worked on the birds over the course of a few months. He was asked what his thoughts or feelings arose when he tortured the birds. He stated, it's like a feeling between good and pleasurable. A relief feeling in power. I don't know, it just felt good. Doc, you talked about this tension removal, tension release, right? after the defendant kills a bird or a person, he feels relieved somehow.
That is correct.
When you comment on the manifesto video, you say the video shows the defendant's inability to contain his thoughts any longer. But again, this is your interpretation, right?
It's not.
Well, let me jump ahead, doctor, because the next day in the counselor's office, he was perfectly capable of containing his thoughts, right? He didn't have to say those things there. He chose not to say them, right?
That is correct.
Doctor, there are a couple of other areas you didn't address. I just want to make sure that you agree with me. They're not part of this case. This defendant did not have a learning disability, right?
That is correct.
And you agree that this defendant has very good adaptive skills, right? He has trouble getting out of bed in the morning or getting his things together or getting to school, right? Carrying out a plan.
That is correct.
All right. And you would agree in this case the defendant didn't act on impulse. This was not an impulsive crime.
That is correct.
All right, doctor, I want to move on now. You mentioned in your direct testimony that some of the language in your report came from another report, right?
That is correct.
You said your understanding was you had permission to use it, right? Who told you had permission to use it?
The attorney that retained me.
And who is that attorney?
I don't think it's appropriate for me to mention his name on
Doctor,
national.
I talked to.
Answer the question, sir. The attorney's name is Sheldon.
Sorry,
I think it's Sheldon.
can you spell that for me, doctor?
I think it's SHELLMAN. My spelling could be off.
And doctor, what case was that in?
It was one of my first cases.
In 2019, you said?
Yes.
Do you have your CV in front of you, doctor?
I do.
You can just take a quick look. You list the 20 cases you've been involved in, and I want to make sure I know which case you're talking about.
I'm looking at it right now.
Okay. If you can just see from that list of cases, I think there may be in date order that you might be able to tell us.
I think it's the People versus Lewis. I think it's the People versus Lewis.
All right. And you're saying that that attorney said, here's a report from another expert, and it's okay for you to use parts of that report.
Yes.
What report was that? Who was the expert?
I believe it's Dr. Holden. I'm not sure, but I believe it's Dr. Holden.
May I approach the witness, Your Honor?
Yes. Have you shown defense counsel?
Just hand it to defense counsel. Doctor, I'm showing you what's been marked as People's Proposed Exhibit 65. Would you take a look at that, please? That's a report authored by Dr. Carol E. Holden, stated April 4th of 2018, and it relates to People versus Gary Peters, which is a case in Macomb County Circuit Court. Can you take a look at that, doctor, briefly? Just page through that. Let me know if you recognize that.
This looks like it. I can't verify the report. I think this looks like it, sir.
Okay, we're going to go over it and we can come back to that. So, doctor, can you tell the court which sections of your report that are cut and pasted from someone else's work?
Are cut and pasted.
What I'm looking for, doctor, is the language that you took from someone else's report, language that you did not write yourself.
Sure.
You can look at Dr. Holden's report, or you can look at your report. What I want to know is, in your report, your June 16th report, which parts did you take from someone else?
Sure. So I actually use the same format as I indicated in my testimony, summary of opinion, sources of information, notification of purposes,
Doctor,
versus.
I want to shorten this up. I'm only interested in what are essentially word for word cut and paste from the report. So I understand there's format and there's some things that are identical, but they're pretty standard. I'm talking about stuff that you just dropped it in.
So my report is 70 pages, and this report is 12 pages. My report has 15 psychological tests, and this report has none.
So, Doctor, I think your answer is you can't tell me right now as you sit here which parts you took from Dr.
Correct.
Holden's report. Okay. Doctor, when did you find out that I knew you had taken portions of someone else's report? When did you learn that?
Actually, through the attorney who retained me.
Okay. And they alerted you. They said, hey, the prosecutor's office is asking for Dr. Holden's report, and I think there's something up.
I don't know about I know about Ethan's attorney who retained me.
Okay. They brought you the report and said, hey, or they said to you, there's an issue here, right? You didn't bring it to them.
So you keep saying they, sir. I can only tell you one person that I had a conversation with.
Okay.
And that is Paulette Lupton.
Okay. About this report, and it's not you told her, it's she told you.
Correct.
Okay. All right. So what I want to do is look at what I'd like you to do is first on the first page of so I want you to look at Dr. Holden's report. I apologize. The first page, she indicates that Mr. Peters was referred to her, quote, for a psychological evaluation focused particularly on the sentencing factors outlined in Miller versus Alabama. Do you see that? It's on the first page.
Yes.
Okay.
On the
And-
summary of opinion?
Yes.
Yes, I see that. Sir.
And doctor, that's the same reason that the defendant was referred to you, right? It's the same purpose.
Absolutely.
Okay. And then, doctor, I want to go through a little bit of the substance of that report. If you look, Dr. Holden references that the defendant in that case, Mr. Peters, was repeatedly placed out of his home over his entire childhood. That's going to be on pages 3 to 5 of her report. You know what, doctor, we're going to save a little bit of time here. I'm going to represent to you that in that report, Dr. Holden reviews the Mr. Peters' out-of-home placement on pages 3 to 5. She references his record of delinquency on pages 4 to 5, and she references his prison record on pages 9 through 11 of her report. And then, doctor, I want you to turn to, I believe it's page 11.
Also, so you're aware, I don't have the report that you're referencing.
Yeah. Pardon me, Judge, if it's all right, I'll give you a copy, and then once I've established with the doctor, I'll move to admit it. Is that?
Any objection, folks?
At this point, I am objecting, yes.
Thank you. I will wait until it's actually admitted into evidence.
All right, doctor. So let's turn, I believe it's on page 11. All right, sorry, doctor, page 12, the last real full paragraph, it starts in formulating my opinion. You see that?
I do.
It says, I gave the juvenile's potential for rehabilitation considerable weight because the amount of time since Mr. Peters was originally sentenced offers the opportunity to assess this factor in a way not possible when he was 17, right? You see that?
Yes, sir.
And then it says, all right, sorry, we're back to page 11, second paragraph under conclusion. And it starts, the extent to which a psychological evaluation may be of value to a sentencer. You see that?
I do.
And then at the bottom of that paragraph, it says from research on, for example, adolescent psychological and brain development, trauma, out-of-home placement, delinquency, and prison adjustment. You see that?
I do.
All right, now what I'd like you to do, doctor, is you've got Dr. Holden's report, right?
I do.
I want you to open that back to page 11. And I'm going to open my copy of your June 16th report. And I know the court has a copy also of the June 16th report where you say conclusion. What I'd like you to do is read Dr. Peters' report, starting with the word conclusion. Dr. Holden's report regarding Mr. Peters. And so what I'd like you to do is read with the word, starting with the word conclusion, start reading Dr. Peters' 2018 report.
Dr. Holden.
Dr. Holden. Thank you.
Certainly. Would you like me to start?
Yes, please.
Sure. So Miller v. Alabama requires that the sentencer take into account how children are different and how those differences counsel against irrevocably sentencing them to life in prison. And that's a quote. By considering the factors discussed above.
Please continue.
The extent to which psychological evaluation may be of value to a sentencer varies across the factors, and how best to weigh and combine the factors in sentencing. A given individual is, of course, a legal rather than psychological question. I consider the factors from a forensic psychologist's perspective, taking into account information obtained from Mr. Peters and from available records from research on, for example, adolescence, psychological and brain development, trauma, out-of-home placement, delinquency, and prison adjustment, and from my current psychological evaluation.
Please continue.
As described in detail above, at the time of his offense, Mr. Peters was a late adolescent. Psychological and neuroscience research has clearly demonstrated that even late adolescents are different from adults. And consistent with this research, compared to an adult, young Mr. Peters was less capable of considering alternatives, more focused on potential rewards versus potential risk, more likely to take such a risk, and less able to consider the long-term consequences of his actions. Mr. Peters' impulsivity, and failure to consider the consequences of his actions, lack of social skills and vulnerability.
Doctor, I want to stop you just for 1 second. So there's a part here where it deviates from your report. Go ahead and continue though. Lack of social skills.
And vulnerability to peer pressure and immaturity were particularly striking to the MDOC psychologist who evaluated him early in his incarceration, as was the fact that Mr. Peters' antisocial and angry attitudes and behaviors so clearly served to ward off many painful feelings.
All right, now, Doctor, I want to jump down to that last paragraph on page 12 of Dr. Holden's report that starts with the above. Can you read that, please?
With the above and the court's assertion that the distinctive, and this is quote, the distinctive attributes of youth diminishes the phenological justification for imposing the harshest sentence on juvenile offenders, even when they commit terrible crimes. End of quote. In mine, it is my opinion that consideration of the Miller v. Alabama factors, especially the final factor, supports a sentence other than life without parole for Mr. Peters.
All right, so Doctor, we followed along, and that's virtually word for word with just a few changes, mostly the defendant's name from the two reports. You are not denying that that's where you got this language, correct?
I am not.
All right. I move to admit people's proposed 65.
Your Honor, I am objecting. I don't believe it's relevant. This is a different defendant, a different fact pattern, a completely different case. And Dr. King has testified that he used the rubric from this report. I don't think that the court then needs to have the report to be able to come to the conclusion that he has used somebody else's rubric, not somebody else's opinion, but somebody else's rubric. I don't think the facts and the specifics of a case from years ago in 2019 is relevant in this case whatsoever. So I'm objecting.
Your response? Judge, I think the court can take it for what it's worth, but I actually want to talk to the doctor about the fact that the contents of this report, Dr. Holden's report, fit her conclusion. The contents of Dr. King's report do not.
You can ask him that question, but I don't see the need to admit it. I was actually following along as the doctor was reading from Dr. Holden's report, and it's clear that there is some language from that report that is significantly similar, if not the same, in his report that's on page 68. So I would note that the court doesn't need to have that admitted, but you can very well ask him questions about that.
Thank you, Your Honor.
Thank you.
Doctor, you use the word I, and then you say it is my opinion that you were especially relying on the final Miller factor, didn't you? That's that last paragraph.
That is correct.
So now I'm looking at your reports. We're on page 69 at the very top. It is my opinion that considering the Miller of the Miller versus Alabama factors, especially the final factor, supports a sentence other than life without parole for Ethan. But doctor, that's in fact not your opinion, is it?
It is my opinion.
What's the final factor, doctor?
And that is the juvenile's potential for rehabilitation.
Doctor, how many times does the word rehabilitation appear in your report? I can help you out one time, and it's not in reference to the defendant. It's the Americans with Disabilities and Rehabilitation Act.
Okay.
How many times do you discuss the defendant's future, his potential in any way, shape, or form?
How many times?
Do you discuss this defendant's future, his potential for rehabilitation in any way, shape, or form? Anything in your report that addresses that?
I think it's contained throughout my report in terms of his mental illness and ability to respond.
Why don't you point out where that is, doctor? Because I don't see it.
It's throughout my report. I don't know that there's a specific sentence. If you're looking for like the exact sentence, it's not in there.
Not looking for the exact sentence. I'm looking for any sentence, doctor. So, doctor, the quote you just took from Dr. Holden, you talk about the defendant's impulsivity. You just read that. And in fact, you agree this defendant's crime had nothing to do with impulsivity, right? You've already testified to that.
I've testified that he's not impulsive.
Correct. That this was not an impulsive act. You testified to that. I asked you.
Right.
Okay.
That's
And
right.
so when you put that in your report, that shouldn't be there. That's because you cut and pasted it, right?
The defendant is impulsive in relation to the crime. It was not an impulsive act. It was a well-planned out act.
All right. Okay. So, doctor, also, I want to go back a page. So we're at the first paragraph under sentencing request. So this is page 68, first paragraph under sentencing request, last sentence of that first paragraph. You talk about out-of-home placement, delinquency, and prison adjustment. You see that? This is your report now, page 68.
Good section of it now.
So are you looking in the first paragraph under sentencing request on page 68?
Yes, Your Honor. It's the last sentence of that first paragraph.
Page 68. I'm still trying to get there. You seeing the first paragraph of page 68?
May I approach, Your Honor? Just
Yes.
So, doctor, I'm looking at sentencing request, first paragraph, last sentence. So I'm looking at research on, for example, adolescent psychological and brain development.
I see that now.
Can you
Thank you.
finish out that sentence? Out of home placement, delinquency, and prison adjustment. You see that?
Yes.
All right. You don't make any mention of foster care of an out of home placement in your report regarding this defendant, do you?
That is correct.
In fact, this defendant was never placed out of his home, was he?
He was never.
And he never went to foster care, right?
That is correct.
You make no reference to delinquency in your report regarding this defendant, do you?
That is correct.
Okay, and in fact, this defendant did not have any record of delinquency, did he?
He did not.
And you don't make a reference to a prison record in your report, do you?
That That is correct.
Defendant's never been to prison, has he?
That is correct.
All right. And to the extent he's been in jail, you didn't review those records or include anything about that in your report.
Can you repeat that, please?
So this mentions prison adjustment. What I'm saying is he didn't go to prison, and to the extent that he's been in jail, you didn't address that in your report.
That is correct.
All right. All right, so doctor, if you look at the probably page 3 of your report, maybe 4, let's see. All right, page 4 of your June report, Miller versus Alabama factors. You never list the potential for rehabilitation as a factor. You agree with me?
Which page are you on, sir?
I'm looking at page 4, where at the top you say Miller versus Alabama factors, and then you have chronological age as the first thing, right?
That is correct.
And what I'm trying to establish is nowhere in your report do you ever list the potential for rehabilitation as a Miller factor, do you?
That's correct.
That
may be correct.
Okay, you don't list as a factor, and then you don't discuss rehabilitation or potential rehabilitation, correct?
Throughout my report, no.
All right, you don't explicitly discuss it. You discuss it. You say it's part of your whole report.
Correct.
Doctor, not listing that as a factor and not explicitly discussing that was a conscious decision you made, correct?
It's not listed, sir.
And I'm asking you, doctor, that was a conscious decision you made. Doctor, in your Jamar Johnson report, you know who Jamar Johnson is, right?
I think he's someone that I'm assuming he's someone that I evaluated years ago or several months ago.
All right. Doctor, in 2020, you wrote a report regarding a Jamar Johnson for Wayne County, it looks like. You familiar with that? You want to look at your CV? You agree that you wrote a report for Jamar Johnson?
The names, I'm pretty sure I did. I take your word for it, sir.
Judge, I don't intend to admit this, but may I approach the witness, see if I can refresh his recollection?
I don't have a copy of it, Your Honor.
Thank you. Can you show the fence before you approach?
I can. Doctor, what I'm showing you is, just to refresh your recollection, this is a September 24th, 2020 report that I believe you authored, that I want to see if it refreshes your recollection.
This is my report, sir.
Okay, and in that report, you specifically list the potential for rehabilitation as a factor, right?
I probably did.
It's a heading, so if you flip through, it's not just buried in there. It's a heading. It says potential rehabilitation.
Okay.
So what I'm trying to establish here, doctor, is that when you've addressed that factor before, you've expressly included in your report, you know it's a Miller factor, and you made a conscious decision not to include it in the report regarding this defendant.
I don't know that I made a conscious decision. It's not included. That's what I can tell you. It's not included.
Was it a mistake?
Sir, it's not included.
Doctor, I'm aware it's not included. I'm trying to ask you why. Because what I'm suggesting to you, and what I'm asking you is, you made a conscious decision. You decided not to include it.
That is correct.
Okay. Doctor, you also made that same decision. I can take that back from you now. Okay. Also, Dr. Holden's report. Thank you. Okay. There are two other Miller factors you don't list and you don't address. So the fourth Miller factor is the incompetencies of youth which affect whether the juvenile might have been charged with and convicted of a lesser crime. For example, because the juvenile did not have the capacity to assist their attorney in their own defense. Would you agree with me, doctor? You didn't list that as a Miller factor in your report regarding this defendant.
I think that's correct.
And in fact, that's because it's a conscious decision. It doesn't apply here, right? There wasn't any plea deal. There was that has no relevance to this case.
That is correct.
All right. And in fact, you also don't list the third Miller factor, right? Which is the circumstances of the homicide offense, including the extent of the juvenile's participation in the conduct and the way familial and peer pressures may have affected the juvenile.
That is correct.
So you agree that's not in your report, and that's a conscious decision, right? Because in this case, it's just not mitigating.
It's not in the report, sir.
Doctor, I know it's not in the report. What I'm asking you is, you consciously decided, your job was to find mitigating facts, right? That was your job. And you looked at all the factors, right?
Certainly.
And you determined that some factors you could provide some mitigating evidence on, right?
I did.
And on the third factor, the circumstance of the homicide offense, including the extent of his participation in the way familial and peer pressure may have affected the juvenile, you didn't list it and you didn't address it because it's not mitigating, right?
That is correct.
So, doctor, you've never evaluated any other mass shooters, correct?
No, sir.
You aware how many mass shooters there have ever been in Michigan since 1966?
I'm not aware.
5. And you know how many of those defendants were under 18 when they committed the shooting?
No, sir.
Only one, this defendant. You know how many people under 18 have committed a school mass shooting where there are 4 or more people killed since 1966 in the entire country?
I know since 1999, there's been over 386 mass shootings.
4 more killed, doctor. It's a much smaller group. 16 since 1966 mass school shooters in the country. And you know how many of those survived?
Can you repeat that, sir?
How many of those 16 survived? Do you know?
I'm not aware.
All right, 7. 7 of those people survived. And my question to you, doctor, is how many mass shooters ever have committed their mass shooting with a plan to survive, not to kill themselves, not to get gunned down by the police, but with a specific plan to survive and go to prison for life so they could see their victims suffering?
I don't know how many, sir.
Can you name one?
I said I don't know any.
Right. Just a couple of hopefully quick things. Doctor, you mentioned something about with his parents, someone doing something out of spite, his father doing something out of spite. You remember that?
I do.
What was that in reference to?
I believe it was in reference to his father buying him a gun.
Oh, out of spite against his mother.
I think that's what I referenced.
Where did you learn that?
I'm sorry?
Where did you learn that? Like, what did that come from, that reference? Where did you get that information?
From the defendant.
Okay. Doctor, you referenced, this is something I want to come back to. So in your January report at the end, you referenced the defendant sitting in a corner and crying. You remember we went over that, right?
I think he says sitting in the cafeteria.
Okay, sitting in a cafeteria and crying. And I said, that's not in your June report. And then you said, yes, it is. You had one, but then we established there's the one that we're working from does not have that
is correct.
sentence. And I said to you, where did you get that from? What I'm saying to you, doctor, that didn't happen. That's what I'm trying to say to you. And you're saying it did.
Sitting in the cafeteria?
Crying.
That was my impression, sir.
Your statement is, again, it's the January 27th report, and it says that
I'm going to object at this point. This has already been asked and answered. He already discussed the statement that was in one report and not in the other report, and he gave a context for that. This has already been answered.
Sure, I need to hear the question first. He hasn't answered the
Understood.
question.
So Doctor, we noted the sentence. I want to read you the sentence. Surveillance video shows the defendant sitting on the ground, crying, fully well knowing that he's on a path of no return. That was the sentence in your January report and the one you brought to court today, right?
Okay.
And I said to you basically, that didn't happen, right? Did that happen?
In my viewing of the video, sir, I observed the defendant sitting by himself and appeared to be crying.
So he wasn't sitting on the ground, right?
Wherever he was sitting, sir, that is what I was referring to.
Can you explain why that was taken out of your report?
Absolutely.
Who took it out?
You will recall. I did.
Counsel, you asked another question while he's trying
I'm
to
sorry.
answer your first question. Please re-ask your question.
Who took that sentence out of your report?
I'm responsible for my reports, sir. I did.
Okay, and why?
My report has gone through, and you are aware also that it has gone through a transition.
You can continue to answer, sir. I'm listening.
Matter of fact, I have sent several versions of the report, sir, and matter of fact, one recommendation came from your office that I should revise my report and include the journal and the board video, and then we sent another iteration. So the report that we're talking about has been a living, breathing document. We've been asked to send revision, and that is exactly what we did.
You're right, doctor. We did bring that to your attention through counsel, right?
Sure.
And we said that the defendant needs a thorough report that addressed all of the facts in the case, right?
Absolutely.
Including things that happened the night before, like his parents kicking him out, right?
That is correct. So that explains the revision of my report.
It doesn't explain this sentence. And it's funny, doctor, now when I'm asking you the question, you say, well, that was your impression, or he was sitting by himself. But when I asked you this morning, you told me that that happened and that you saw it on a video from the cafeteria, correct?
That is correct.
Do you want to look at that video?
Do I want to look at it?
Do you want to look at that video? Because doctor, that's not on there.
Okay.
For the record, you're showing something on the screen.
Yes, Your Honor. This is a video that's taken from the school cafeteria between the time of, this is at 11:51 a.m. So this is after the meeting with the counselor in the office before the shooting. Pardon me, 11:53. And what this shows is the defendant who's on the left side of the hallway, walking towards the frame. He's going to walk up. He's going to sit down at the table in the lower right. And then he sits there for about 15 minutes. He's on his phone. He does not sit on the ground. And I've looked at it. There's no sign that he's crying. He's simply on his phone sitting there. So we can show that now. Oh, it's already
the full 15 minutes.
I think only, Judge, if the witness tells me I'm going to see something other than what we see right now, which is the defendant on his phone at the table. When you watch the whole thing, doctor, you see anything other than that?
That's the video that I saw.
Okay. There's 15 minutes. Do we need to watch the rest? Do you agree? That's what it shows.
I don't think it's necessary, but it's just your call.
Also, respectfully, I don't need to see this video for 15 minutes. It's a waste of time. So I'm going to ask that you move on.
Thank you, Your Honor. I will. Yeah. So, doctor, can you list the things that when we talked to you through counsel, we said, look, you got to address this stuff. Do you know what those things were? The things you didn't address in your first report?
So I don't think there's any way for me to recall. It's not humanly possible.
Okay.
I looked at thousands of pages and videos and journals, and it's not practical for me to tell you 1, 2, 3, 4, 5. It's just not possible.
All right. But you did make changes, and they were partly at our request, and they were to actually mention things like the journal, right?
Yes, you asked me to revise through counsel. You asked me to revise my report, and we did, and we sent revisions over to your office.
Doctor, actually what we asked is that you include all of the evidence, that you address all of the facts before the court, right? That you address the very obvious things that need to be addressed, like the journal, the text messages, the internet searches, right?
So it's not possible for me to send you 20,000 text messages. They could not have been included in my report. It wasn't possible.
Thank you, sir. Thank you, Your Honor.
Thank you. Before we redirect, we're going to take about a 5 to 10 minute break.
Understood.
Before we take a break, counsel, please approach. On break. To the media, you are not to record the bench conferences. I know that my staff sent me a note that says that this microphone was recording our last bench conference. That shall not happen.
I want to talk about the phone call with the neighbor. Was it your understanding that this neighbor appeared in the news and then contacted me?
Yes, that is correct.
And then that person was willing to contact you, correct?
That is correct.
And you had a full conversation with this person, correct?
That is correct.
Okay. And they identified themselves as a neighbor?
That is correct.
And in that phone call, was it detailed to you, the same thing that had been detailed in a number of investigators' reports, that Ethan was left home alone often from a young age?
That is correct.
If you were to list in your report every single text message, video, the 10,000 pages plus of discovery, how long would your report be?
At least 5,000 pages.
Did you pick and choose what you thought was the most important to your findings and put it in your report?
I did.
So when Mr. Williams goes through the things that you did not include, and you had answered the questions, I do think those things are important. Is it true that you took those into account? You may have not said the words about the video, said each word about the journal, but were all of those things in your mind when you rendered an opinion?
Yes, ma'am.
I want to talk about ACEs because there was so much discussion about that. Do you need to perform the ACEs test to conclude what you did?
No, you don't.
And why is that?
Because once you have the information for that assessment, there is no reason to, once again, go over each question because you already have the information.
We went over the fact that there is a copy of your report dated in January that was turned in April, and then there's the report dated in June. Then there was some conversation or some questioning about the fact that it was the prosecutor's office had asked that you include more details into your report about certain things. Do you remember that line of questioning?
That is correct. Yes.
Okay. You had already viewed those things that were not included in your report when you authored your first report, correct?
That is correct.
Okay. So because they weren't present or they weren't in that first report, is that because they weren't important to you or that you didn't consider them, or you simply just didn't put that in your report?
That is correct. I just did not put them in my report.
And when we re-examined the report dated in January, we went over all of your findings and all of the evidence, correct?
That is correct.
Your opinion did not change from the January report to the June report, correct?
That is correct.
You changed words, but you didn't change your opinion, correct?
That is correct.
There was conversation about the violent videos. So if a person has violent thoughts and then continues to watch these violent videos day in and day out, what happens to that person?
Essentially, that person loses sight of reality and begins to fantasize about what they're feasting on, and then sort of start imagining themselves as a part of the action.
So it was mentioned, because it's mentioned in Dr. Aniker's report, that at a very young age, Ethan has a conversation with a teacher about, wouldn't it be funny or wouldn't it be nice if, you know, all these people end up in a car accident and then there's death. And the prosecutor had asked you questions. Well, look, he already has violent thoughts. So if someone's starting at a young age with these violent thoughts and then they watch the videos, how does that affect them?
It can only get worse. It's actually a recipe for disaster.
There was conversation about the video games. You were made aware that Ethan had started playing these violent video games at a very young age, correct?
That is correct.
The purpose of a criminal responsibility exam, what Dr. Aniker performed, is different than what you are here for today, correct?
That is correct.
There's a different purpose for your report, correct?
That is correct.
There was a lot of time spent on page 61, objective sources. What are objective sources?
Objective sources are sources outside of the evaluator. For instance, a video will be considered an objective source.
Okay.
Because it's something not inspired by the evaluator.
What about text messages or a journal?
Yes, those are objective sources.
Okay. So when you're talking about objective sources, are these the things that you're talking about?
That is correct.
There was some conversation that when you're testing Ethan, you're only going off of what he's self-reporting. Do you remember that line of questions?
I do.
You also explained in direct that you tested him to see if he was feigning or faking, correct?
That is correct.
Can you describe for the court how you did that and why?
So psychological tests have built-in validity scales, and the respondent does not know the questions that comprise the validity scales. And, these scales have been validated for years and years and years, so they have nothing at all to do with me. I just use the instrument. And if he were feigning, then his profile would have looked different. But based on the validity scales, and for instance, the mini mental status exam, which is a screening tool, and it gives the defendant the opportunity to feign or to fake the answers if he or she wants to. And if they do that, then their scores will be very different from normal people. So when I looked at Ethan's responses, they were very consistent with neurotypical. So that's how I knew that he was not feigning. Also, on the evaluation of competency to stand trial, as I mentioned, that instrument is recognized by the United States Supreme Court, 1960, the People versus Dusky. And on the scales, he appeared competent to stand trial. If he wanted to, he could have feigned those answers, but he did not.
There was a lot of questioning about Ethan's behavior following the shooting. The fact that he goes in the hallway, surrenders, he follows the directives of the sheriffs. He then is in the police car and there's no issues. There's no video showing him talking to voices out loud or appearing to be in distress. Does that change your opinion about whether or not he was suffering from mental illness on that day?
It does not.
You had discussed kind of a release. Can you explain that again briefly to the court, why your opinion doesn't change, even though his behavior, he's able to comport back to reality and follow directions?
Sure. So mental illness is a dynamic process. I think I used examples of Robin Williams. I used examples of Twitch. And there is a United States senator who not too long ago checked himself in due to clinical depression. And he represents this country at the highest level, but he raised his hand and he said, I need help, I'm clinically depressed.
Mm-hmm.
And so the point I'm making is that mental illness is a dynamic process. There are some days when you can go to work and you show up and you do well. And then there's some days when you're not doing well. Well, that is mental illness. That's what it looks like.
And psychosis itself, it isn't always what we envision as talking to voices or acting animated, correct?
That is correct.
So even though Ethan is not experiencing visible symptoms, that doesn't mean that anyone can conclude that he isn't exhibiting symptoms internally of psychosis. Is that fair?
That is fair, because if someone comes to that conclusion, then of the four things that I showed, they're guessing.
I want to talk a little bit about psychosis. If someone is having a psychotic episode, are they in it permanently, Or do they then at some point regain their ability to be in reality?
Sure, it waxes and it wanes. I have had the opportunity to hospitalize several, over 20 years, several mentally ill patients. And after treatment at a hospital, a number of them will return back to the group home. And within a couple of weeks, they were able to regain their neural typical function, like going to work, taking their medication, and making informed decisions. So again, mental illness is a dynamic process, and some people assume that to be mentally ill, you have to be foaming at the mouth. You know, I used the example, Senator Fetterman. He has clinical depression, but he's going to work now. Does that mean that he's not mentally ill? He raised his hand and said, I need help.
So there was some conversation about the time on the messages, and because of the actual time is not the 4:30 a.m. that you had referenced in your report. Does that change your opinion at all, that it is in the late evening, early morning hours as opposed to 4 in the morning?
It is immaterial.
And Ethan self-reported to you that he was not sleeping, correct?
That is correct.
There was a lot of conversation on page 26 where you indicate sorrow over the outcome of his actions. And Mr. Williams took some time to say that you didn't follow up with the questions, and we don't know why he's sorrow or he's upset. Maybe he's just upset because he finds himself in jail. That testing, it is a set of questions that you ask. There is no follow-up, correct?
That is correct.
That test doesn't look for the reason, it looks for the symptom.
That's exactly what it does.
There was a lot of questions about what do you base your statements on? You don't have a site here. You've been qualified as an expert, correct?
Several times.
And you're here today to give your expert opinion, correct?
Yes, ma'am.
You were asked questions about how many millions of people suffer from depression and the fact that not all of them become mass shooters. You remember that question?
I do.
And that's because most of them get intervention, correct?
Absolutely correct.
That's because good parents recognize when their child is circling the drain, correct?
That is correct.
I want to talk a little bit about implicit bias. You don't blame defendants' actions on implicit bias, correct?
I do not.
Then why are you giving us the context of implicit bias? How does this fit with the facts of this case?
Absolutely. So some people misconstrue the concept of implicit bias.
Is it racism?
It has nothing to do with racism. And I just want to make that clear for the record. In no way, shape, or form am I saying that the Oxford school system is a racist system. That is not what I'm saying. Implicit bias has to do with being given information and evidence, but because of your unconscious impulses, you don't take action that you should take. That is the basic concept of implicit bias.
So this isn't an excuse that you're giving for Ethan. This is an explanation. Is that correct?
It's an explanation.
There was questions asked about the fact that you don't know for sure that a teacher saw all of these assignments that were found in his backpack. Do you remember that?
I do.
But you were made aware of a note card that a teacher, when reviewing after seeing him search bullets and search other things, went back and looked at an assignment from September that she had not realized before, where in fact he drew himself or an individual with a weapon and then erased the weapon, but it was still obvious. Is that correct?
Yes, ma'am, that is correct.
So we know for sure that that assignment was received.
We know at least one assignment was turned in and was reviewed as confirmed by the teacher. That is a fact, and that we do know.
And we do know that that assignment was overlooked because it wasn't until November 29th or 30th that this teacher then went back to examine what he had turned in previously and discovered this, correct?
That is correct.
There's also no grade or score on that final assignment, the test review, which finally led him to being taken to the office, correct?
That is correct.
So we know that a teacher walking around and looking at what the students were writing observed that.
Yes, ma'am.
There were some questions about the fact that he was in the counseling office and he could have said, I've got a gun in my backpack, I need help. And that's true, correct?
That is absolutely true.
But he also, as you testified, wrote in his own words on the school assignment, help me, my life is useless, the world is dead, blood everywhere, correct?
Yes, ma'am, that is correct.
There was a line of questioning about the fact that he was obsessed with harming people. It goes to, we're talking about the torturing of the birds, the voluminous text messages about this desire to want to kill. That's because he was mentally ill, correct?
Ethan is mentally ill, and there is no doubt in my mind, based on the testing results, and that cannot be refuted based on the testing results.
So Mr. Williams spent some time talking about motivation. Are you able to rationalize what Ethan did leading up to November 30th?
I just want to say this, a number of innocent people died. And I'm not here to make excuses for Ethan Crumbley. A lot of innocent people died. He planned the attack, and my heart goes out to the victims and their families.
So are you able to rationalize the steps that he took, or is it irrational because he was mentally ill?
He was mentally ill.
And please rephrase your question. Sir, I need you to listen to the question. A few of your responses have been unresponsive to the question. So I need you to listen to the question that's being asked of you. Please rephrase your question or re-ask it.
I will re-ask it.
Thank you.
There was a line of questioning about what motivated Ethan. Do you remember that line of questioning?
Yes, that's correct.
And you were unable to say specifically what it was that motivated him, correct?
That is correct.
Do you believe it was mental illness that motivated him to do all the research that he did, to plan out his attack and the actual shooting?
I do.
You were asked a number of questions of the journal. There is no argument that what he wrote in there is alarming. Do you agree with me?
I do agree.
Do those look like rational thoughts from someone that does not have a mental illness?
They do not.
Do the ramblings in that journal line up with the compulsive behavior that you described?
Yes, ma'am.
Does it line up with the anxiety that you described?
Yes, ma'am.
Does it line up with the depression that you described?
Yes, ma'am.
I want to talk about the bird videos and the pleasure he finds in it. In watching the video, and I know that you touched on the fact that you can even hear like an elevated voice. What do those videos show you?
The videos show a very ill individual deriving pleasure from the torture of the birds. That's what they show.
There was a lot of questions about the fact that you did not write every specific fact or any of the specific facts that occurred in this case. To your knowledge, are any of those facts at issue?
I don't think so.
Okay. And you were told that Ethan pled guilty to all of the charges, correct?
That is my understanding.
Ethan never reported to you that it did not happen, correct?
That is correct.
There was some questioning asked about the fact that he was focusing on younger children, younger birds, helpless people. What do you make of that?
So he certainly targeted younger birds first and fantasized about hurting younger people. And given the level of obsession and compulsion,
we sort of moved on from there to real people. Well, other people, I should say.
The fact that there is premeditation and planning, does that mean that Ethan is not mentally ill?
No.
The fact that he discussing wanting to be famous, are those the thoughts of someone with a healthy brain or an unhealthy brain?
Unhealthy brain.
I want to talk about Dr. Holden's report. Dr. Holden is a well-respected expert, correct?
She is.
She doesn't do any of the testing that you did, correct?
I have not noticed any testing from Dr. Holden.
The report that brother counsel showed you did not have any testing, correct?
It did not.
Did you come to your opinion on this case based on your testing in this case?
Yes, ma'am.
So when I made you aware that this would probably be something that Mr. Williams would address with you, you reviewed the report from Dr. Holden, correct?
I did.
And what steps did you take that you can tell us when you compared your report to Dr. Holden's report?
Am I able to reference any document? I mean, I can tell you.
Would it assist your answer by looking at a document and I can provide it to brother counsel? Would you be able to answer your question if you're able to look at the papers contained in your folder there?
Yes, ma'am.
Thank you. You may approach the witness. Please show the prosecutor.
And he actually has a copy.
Thank you.
So what is it that you did with your report compared to Dr. Holden's report?
So when the concerns were raised about the similarity of their reports, and I've done this before, I tasked my assistant with doing 2 independent searches. There's a program called CopyLeaks and another one called editpad.org. What these programs do, they take one report, line it up with the other, and then they look for similarities and consistencies or differences. So that's what I had my assistant do, just because I anticipated that this was going to be an issue. So I have the results that my assistant ran.
Okay, so I want to focus on identical match. What percentage of these 2 reports is an identical match?
Judge, I'm going to object to this until that other report is admitted. I don't think this document in any way, I want Dr. Holden's report admitted before there's a comparison, please.
Thank you. So I need to understand your legal objection. What's your legal objection to this line of question?
That there's not a foundation for this testimony without Dr. Holden's report. This is now a comparison between his report and Dr. Holden's report. Her report is not in evidence.
Thank you. I agree with that, but I haven't seen Dr. Holden's report either, so that's not substantive evidence that's before this court. So the objection is overruled. You may continue with your line of questioning, but noting that the court has no idea what's inside Dr. Holden's report.
Understood. Thank you very much. I'm just going to ask one question. The percentage of the identical match between the 2 reports is what?
1.3%.
Thank you. You were also asked and shown your report on a case of People versus Jamar Johnson, correct?
That is correct.
It's my understanding from that case, Mr. Johnson had already done a significant period of time in prison, correct?
That is correct.
And so you were able to review prison records for a number of years for Mr. Johnson, correct?
That is correct.
So would you agree with me that it would be much easier to talk about the rehabilitation prospects or the actual rehabilitation when you have years of prison records showing that he either changed his behavior or listing all of the good things that he's done?
That is correct.
So your report here on Mr. Crumbley is different and different than probably almost all of the reports you completed because Mr. Crumbley hasn't been to prison yet, correct?
That is correct.
So you don't have a number of years of behavior, tickets, programs completed to look at, correct?
That is correct.
You were asked about the fourth Miller factor and the fact that you didn't address it, but you did actually do a competency test where you measure if he's able to assist his attorney in his own defense, correct?
That is correct.
So you may not have actually listed that fourth factor, but you definitely addressed it, correct?
I did.
May I have one moment?
Yes.
I have no further questions.
Judge, just very briefly.
Council approach. Thank you. The court will note that the time is approximately 3:44 p.m. I note that the people intend on calling a rebuttal witness. Defense, do you have any further witnesses at this time?
We don't have any further witnesses, Your Honor, but I'm asking that you note the last 4 exhibits in my binder that have been admitted. Exhibit T, there are letters of support from 2 family members of Ethan Crumbley. Exhibit U, it's a report of the legal guardian ad litem, Ms. McKelvey. V, the Violence Project report, which is a report that was created at the people's request in the parents' case. And W, a stipulation on the GED examination that will show that Ethan Crumbley paid for and completed all necessary testing to be able to take the GED, but unfortunately the jail could not accommodate that. Other than that, Your Honor, we rest.
Thank you. The court will so reflect counsel statements this afternoon. I note again that the people intend on calling a rebuttal witness. The time, we're late in the day, and so there's no way possible that we're going to be able to get through the people's rebuttal witness before 4:30 p.m. I will also note that you all cannot return tomorrow. As you all are aware, we had to put a lot of things in place in order to have these hearings for 3 days. And so we need to make sure for building safety issues, we need to make sure that we also confer with the Oakland County Sheriff's Department. And so to make all of that happen, we need to adjourn this to another date, as well as the court is unavailable for some dates. And so the return date that I discussed with counsel is August 18th, 2023 at 9 a.m. Counsel's already confirmed that that date works for them. I will also note that we need to address the defendant's placement at the Oakland County Jail, as we must review that every 30 days. People, any statements that relates to the defendant's placement at the Oakland County Jail?
Judge, we don't believe there's any changes. We believe the placement's appropriate.
Thank you, defense.
We have no arguments.
Thank you. Based upon the court's previous rulings, the court does continue to believe that it is in the best interest of justice to continue the defendant's placement at the Oakland County Jail. We will return here August 18th, 2023 at 9 a.m. to continue this hearing. At that time, the court will also give you another review hearing date as well as a decision date. As I discussed off the record, there are some things that I need to address with the Michigan Department of Corrections before I set a sentencing date in this case. Anything else we need to address for the record before we end for today?
No, Your Honor.
No, Your Honor, thank you.
Thank you. Deputy, you may take the defendant. And please be seated in the courtroom while he's exiting. Thank you. Court stands in recess. You all have a good day. Thank you.
All rise.
Thank you, Judge.
Rita, do you mind if I lock up a couple things because I didn't bring all my cards today? Do you, or whatever, I mean, this.